Senate Judiciary Committee will come to order. Welcome, everyone. We have a conflict with the Senate Appropriations Committee, and several of us are on both committees. They will be starting their meeting sometime this morning, and we may be called to attend. Senator Coons, for example, has a bill, if I'm not mistaken, before the committee. So we'll work to accommodate everyone's schedule here and try to keep things moving forward. 2 items on today's agenda. We'll vote on one judicial nominee, Julia K. Munley, U.S. District Judge for the Middle District of Pennsylvania. We will also vote on S-359, Supreme Court Ethics, Transparency, and Recusal Act of 2023, sponsored by Senators Feinstein, Klobuchar, Coons, Blumenthal, Hirono, Booker, Padilla, Ossoff, and Welsh. It was 11 years ago in a very different Supreme Court when I first called on Chief Justice Roberts to adopt a binding code of conduct for all Supreme Court justices. Today, the Senate Judiciary Committee will vote on a bill that would finally bring Supreme Court justices' ethics requirement in line with virtually every other public servant in the federal government. I want to commend Senator Whitehouse for his yeoman performance on this piece of legislation. He has worked on it for a long, long time, and I respect the good work he's put into it. This legislation will be a crucial first step in restoring confidence in the court after a steady stream of reports of justices' ethical failures has been released to the public. The public support for the Supreme Court is at an all-time low. I'll speak more about the bill when we turn to it and ask other members to withhold their comments until that moment after we consider the nominee. But now I turn to the ranking member, Senator Graham.
Thank you, Mr. Chairman. I'll respond to your comments about the bill in a minute, but Judge, the nominee, Ms. Munley, we had some concerns about some political donations, but we've looked and I'm satisfied everything is okay, and I'm certainly ready to move forward on her.
Thank you, Senator Graham. Is there anyone who seeks recognition to speak on Judge Munley's nomination? If not, on favorably reporting the nomination of Julia Kathleen Munley to be U.S. District Judge for the Middle District of Pennsylvania, the clerk will call the roll.
Mrs. Feinstein.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar. Aye. Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirono. Aye. Mr. Booker.
Yes.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Welch.
Aye.
Mr. Graham.
Aye.
Mr. Grassley.
No.
Mr. Cornyn.
No by proxy.
Mr. Lee.
No.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No.
Mr. Tillis.
No by proxy.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 12, the nays are 9.
The nomination will be favorably reported to the floor. Next for consideration is S-359, the Supreme Court Ethics, Recusal, and Transparency Act, CERT. The past several months have seen a steady stream of news reports highlighting ethical failures by the highest court in the land, the Supreme Court justices appointed by both Republican and Democratic presidents. Justice Clarence Thomas traveled the world on billionaire Harlan Crow's yacht and private jet. Crow bought the home of Justice Thomas's mother and allowed her to continue living there rent-free. He even paid for the education of a relative of Justice Thomas. None of this was included in Justice Thomas's financial disclosures. Justice Samuel Alito took an all-expense-paid luxury fishing trip to Alaska. He traveled there on the private jet of billionaire hedge fund manager Paul Singer. He stayed at a fishing lodge of conservative donor Robin Arkley. Like Justice Thomas, Justice Alito did not disclose any of these receipts. In explaining this, Justice Alito said he did not believe he was required to disclose the private jet travel because he was sitting in a seat that would otherwise have been empty. Justice Sonia Sotomayor used her tax-funded court staff to promote additional sales of her books in conjunction with speaking engagements. She failed to recuse herself from cases involving her book publisher. If any of the senators or even the staff members sitting in this room today were involved in similar activities, they would be in violation of the ethical rules that govern Congress. That's because all of us are subject to enforceable codes of conduct that prohibit us from accepting gifts and using taxpayers' funds for personal gain. We are required to make public disclosures about our finances, and there are consequences if we fail to meet these standards. But the same is not true for the 9 justices across the street. Unlike every other federal official, Supreme Court justices are not bound by a code of ethical conduct. They are the most powerful judges in America, and yet they are not required to follow even the most basic ethical standards. The CERT Act we are considering would change that. It would finally require the Supreme Court to adopt an enforceable code of conduct. It would also add new recusal and transparency requirements to federal law. In this way, it would bring all 9 justices of the Supreme Court in line with every other federal judge in America. Requiring a code of conduct for Supreme Court justices should not be controversial. Historians and legal scholars from across the political spectrum agree that legislation imposing a code of conduct on the Supreme Court is both necessary and well within Congress's congressional authority. Members of this committee on both sides of the aisle have long led efforts to make the Supreme Court more accountable and transparent. In 2021, our colleague Senator Cornyn, along with our colleague Senator Coons, introduced the Courthouse Ethics and Transparency Act, which required all federal judicial officers, including Supreme Court justices, to file disclosures of certain securities transactions, just like members of Congress. That bill passed the Senate unanimously, both parties, and was signed into law by President Biden, and the Supreme Court is abiding by this congressional action. 2 years ago, this committee, with the support of 5 Republican senators, favorably reported Cameras in the Courtroom Act, a bipartisan bill that I've long introduced with Senator Grassley, and which would require the Supreme Court to permit television coverage of all sessions of the court with only limited exceptions. Some have suggested that Democrats are pursuing Supreme Court ethics reform to target the court's current right-wing majority. Far from it. The reforms we are proposing would apply in equal force to all justices. And, as I mentioned, it was more than 11 years ago, and a very different Supreme Court, when I first urged the Chief Justice to adopt a binding code of conduct. Unfortunately, he did not accept my suggestion. Since then, as more and more stories have emerged of justices' ethical lapses, the American people's confidence in the Supreme Court has dropped to an all-time low. My colleagues, the Supreme Court term begins with the announcement by the Marshal of the United States Supreme Court. He strikes a gavel and he says, "The Honorable, the Chief Justice and Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having businesses before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court." 3 times the Marshal declares that the Supreme Court is honorable. With the enactment of this legislation, our highest court in the land can more rightly make that claim. I now yield to Senator Graham.
Thank you, Mr. Chairman. I appreciate it very much. This will be a spirited debate. I hope you have nowhere to go today, because we've got a lot of amendments that I think are worthy of consideration. A couple of points. What you're trying to do is not improve the court. You're trying to destroy it as it exists. And it's been a long, ongoing effort here. You have to look at this in terms of what's been going on for a couple of years. So Senator Schumer visits the court, goes over to the court a while back and says, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions." This is the majority leader of the United States Senate. Supreme Court justices know they're in for very high-profile positions. They have security. That was the explanation given by a representative from New Hampshire when conservative judges basically had their houses surrounded by a bunch of protesters. And Maxine Waters, who I've known for a long time, like Maxine, you ain't seen nothing yet. To hell with the Supreme Court. We will defy them. Democrats look at packing the Supreme Court. The reason you want to pack it is because you don't like the makeup of the court. You have done just about everything there is to do to delegitimize this court. Members of the Democratic leadership went to the steps of the Supreme Court and literally threatened people. When it comes to Clarence Thomas, the New Republic, I don't get it, but apparently some of y'all do. The Democrats need to destroy Clarence Thomas's reputation. You're trying very hard and you're going to fail miserably. This bill is going nowhere. All of us are going to vote no, and I hope you bring it to the floor. I hope we have a spirited debate about what this bill would do to the court. This is not what Senator Cornyn was trying to do. This is legislation that would fundamentally change the way the court operates. The Supreme Court was created by the Constitution. It's a co-equal branch of the government. Our founding fathers decided to create 3 branches of government, and it set up the Supreme Court in the Constitution. All lower courts are created by statute. The bill you have before us would fundamentally erode the power the Supreme Court has enjoyed over time. It would allow lower court justices to dispose of complaints against the court, subpoena the members of the Supreme Court. It would create a complaint body where anybody could file a complaint against the court, and the complaint would be adjudicated by lower court justices, which strikes at the heart of the court being the Supreme Court. Your recusal mechanism, you can't expand the court. Senator Kennedy said something very smart, as he always does yesterday. This bill would shrink the court. There'd be a massive effort by liberals throughout the country to disqualify conservatives in every major case. And the way you handle recusal is that you micromanage how the court must decide when to recuse. The individual justice no longer would have that power. You would give it to other justices. That is a constitutional assault on the power of the court to do business. So none of us have any illusions about what's going on here. This will be on the 2024 ballot, I hope. The effort to remake a conservative Supreme Court is unlimited. What people on the other side will do in the name of having people on the court they agree with is almost unlimited. When the justices were surrounded in their homes, the Attorney General sat quietly by and didn't do anything about it. So I try to work with you when I can. It took us 50 years to get a conservative court. We did it the old-fashioned way. We nominated people, we got the votes, we worked hard. About Garland and all of these other accusations, we did nothing outside the norms of the Senate when it came to finding people to put on the court. The bottom line is this is a bill not designed to make the court stronger, more ethical. It is a bill to destroy a conservative court. It is a bill to create a situation where conservative judges can be disqualified by statute. It's a bill to rearrange the makeup of how the court governs itself. It's an assault on the court itself. So you complain about what's going on in Israel. I hope they can find a way to deal with their independent judiciary problems. But to be lectured by the Democratic Party is a bit rich. Every one of you has openly suggested we should change the number of the Supreme Court. And if I am wrong, this is your chance to say, no, I don't want to expand the court. Because I believe it is the position of the Democratic Party to expand the number of justices from 9 to probably 13 so that you can dilute the power of a conservative court. Just think how that plays out over time. Every time there's a change of power in the executive branch in Congress, will we change the number to get outcomes we like? That's what you're willing to do. That's the most extreme solution to a problem I could think of. Packing the court destroys the court. Passing legislation to micromanage how the court operates destroys the court. Creating a complaint process in the name of ethics that's designed to disqualify people you don't like destroys the court. This will not stand. I don't know what the vote will be in this committee, but I can assure the American people this ill-conceived effort in the name of reforming the court will go nowhere in the United States Senate.
Thank you, Senator Graham. This senator has not taken a position to increase the number of Supreme Court justices. And let's be clear, there is only one living senator who has changed the size of the Supreme Court. That is Senator McConnell, the Republican leader, who shrank the court to 8 seats for nearly a year and for purely political reasons by refusing to consider Merrick Garland's nomination. Chair recognizes Senator Whitehouse.
If I may, so it is the position of the minority that you do not want to expand the court. Is that the position of the Senate majority?
I only speak for myself.
Okay, well, that's one. It is clear that there's an effort by the left to expand the court. And what Senator McConnell did is consistent to what happened in the Bush administration.
Senator Whitehouse.
Thank you. Let me start by thanking Chairman Durbin for this markup of our Supreme Court Ethics, Recusal, and Transparency Act, and the rest of my Democratic colleagues for co-sponsoring it. This bill would directly address some of the already disclosed misconduct we've seen at the Supreme Court recently. Comprehensive judicial ethics legislation is overdue, but it's worth remembering how we got to today's markup. Let me first be candid about my belief that the Supreme Court has been captured by special interests, much like a railroad commission in the 1890s might have been captured by railroad barons to decide things their way. I knew ethics were haywire at the Supreme Court when I determined that Justice Scalia had taken many dozens of unreported freebie vacations, often with political companions. His theory, evidently, was that a personal invitation from a resort owner he'd never met made the free vacation the sort of personal hospitality that did not need to be reported under federal law. That is, of course, ridiculous. And when I got this notion before the Judicial Conference, they shot it down in flames, the verdict of their fellow judges. Other justices had witnessed this behavior over decades, but did nothing about it, other than in some cases to copy it. Then came the flotillas of coordinated front group amici who showed up at the court. Some amici have been paid by parties. Others have masked special interests out to influence the law. There is a disclosure rule for all of this, but its enforcement is a failure. Here's an appendix I filed showing who is behind one case's flotilla of front groups. The biggest flotilla, no surprise, appeared in the Bonta dark money case, supporting a corporate appendage of the Koch brothers' main political dark money battleship, Americans for Prosperity. I counted 55. 55. And these right-wing front groups have a statistically staggering record of certain justices ruling their way. Then came Justice Thomas in the January 6 cases. The lawfulness or unlawfulness of his failure to recuse depends on simple facts: what he knew about his wife's insurrection activities and when he knew it. To this day, the court has engaged in zero effort to make that factual determination. Worse, it has no means to. It is the only court in the country, and perhaps the only court in the world, with no ethics process at all. Then came the news that six politically active right-wing billionaires have been paying household expenses, engaging in financial transactions, and providing massive secret gifts of travel and hospitality for at least 2 justices. Not one person on this committee could or would accept such a bonanza, let alone keep it secret. Nor would executive branch officials, nor would any other federal judge. And that's before you throw in the repeated companionship of the justices on these travels with the operative at the heart of the court capture scheme. Yet the Supreme Court remains supremely idle. Last 2 points. One, the judiciary has a process for resolving ethics questions and giving ethics advice. The justices seem uniquely to refuse to follow it. For instance, asking random colleagues and friends about financial disclosure obligations instead of asking the actual financial disclosure committee of the judicial conference that is there for that purpose. And the excuses when they're caught have been laughable. For instance, that they don't need to disclose these junkets because a private jet airplane is a facility. And the traveling on that private jet airplane is not travel, but is food, lodging, or entertainment. Remember, as we debate this, the court's financial disclosure requirements are a law passed by Congress. Its recusal requirements are a law passed by Congress. And the body that implements financial disclosure and code of conduct issues is the Judicial Conference, a body created by Congress. Please, let's not pretend that Congress can't make amendments to laws Congress has passed or oversee agencies Congress has created. For decades, the justices themselves have never objected to and have actually repeatedly and without complaint complied with this structure. So even the court has demonstrated it does not believe that canard. We are here because the highest court in the land has the lowest standard of ethics anywhere in the federal government. And justices have exhibited much improper behavior, not least in hapless efforts to excuse the misdeeds. This cannot go on. Defending this behavior defends the indefensible. Thank you, Chairman.
Senator Grassley.
I will be voting against this very partisan Supreme Court Ethics Recusal and Transparency Act. This bill is not about oversight or accountability. It's about harassing and intimidating the Supreme Court. Over the past several years, the far left has mounted an unprecedented assault against the Supreme Court. The far left is unhappy with the court's conservative majority and detests a handful of its decisions. So the far left has resorted to bullying tactics, even considering that only 9% of the court's decisions last year were on a 6-3 division. The far left's playbook is to attack the court, cast doubt on the legitimacy of the institution, impugn the reputation of the justices, and attempt to dictate the rules and practices of a separate branch of government. Since 2020, we've seen proposals to resurrect the failed, misguided idea of court packing. This is a notion overwhelmingly rejected by the American people when it was last proposed during the New Deal era of the 1930s. Nevertheless, some on the left are actively pushing bills to pack the court anyway. FDR could not do it. How do they think they can do it today? In 2022, we saw the extraordinary and unethical leak of the draft Dobbs decision. This was an overt attempt to ramp up public pressure against the court to sway justices before the final decision was issued. Thankfully, these attempts failed. But the far left continues to deploy extreme tactics to smear the court. Conservative justices' homes addresses were publicly posted and shared. Protesters hold weekly demonstrations outside the private homes of justices in violation of federal statute. Justices and their families have been confronted in public, even at restaurants, and sometimes on vacation. This has resulted in a real physical security concern and at least one assassination attempt. Some of these justices have young children who witness these shocking acts of intimidation. Over the past few months, the latest efforts are to manufacture claims of conflict of interest. At first, there were attacks against the spouses of justices who also happen to work in the vast legal field. However, no such claims were lodged against Justice O'Connor or Justice Ginsburg, whose husbands were lawyers while these justices served on the bench. Now there is a drip of stories attacking the travel of conservative justices. These stories conflate trips from years ago, some decades ago, with newly updated disclosure guidelines announced in March of this year. The rule change from the Judicial Conference is related to personal hospitality exceptions to the disclosure. The judiciary took action on its own to bring clarity to what was once overly broad and poorly defined. These stories cherry-pick travel by certain justices. They go on to raise conjecture and misrepresent the facts and fail to explain the rules that were then in place prior to these March 7th changes of regulations. Remember, many of the events in question took place years ago during the court's liberal majority. Where was the outrage from the left at that time? Were they pacified by the court's more liberal decisions? Or is this newfound ethics focus just simply political smoke and mirrors? Well, the answer is obvious. This is all part of the Democrats' promise made at the steps of the Supreme Court in 2020 to release the whirlwind. On May 2nd, the Wall Street Journal editorial board wrote a great article about this and ongoing political theater. The article correctly notes that so-called Supreme Court ethics reforms is another front to the political campaign to delegitimize the Supreme Court with a goal of tarnishing its rulings and subjecting it to more political control, end of quote. Further to quote, though, the campaign is on full display in the press, with reporters at multiple publications suddenly searching for supposed ethics violations or conflict of interest. The paper writes that writers have examined and debunked these reports. This is a political project, and hyped accusations are going to continue to be asserted as if they are serious, end of Wall Street Journal quote. I'd like to enter that into the record. The far left is now calling for purported ethics reforms and recusal reform for the Supreme Court. Chief among them is this bill before us, which raises constitutional concerns, because Article 3, Section 1, Clause 1 of the Constitution states, quote, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may, from time to time, ordain and establish, end quote. Unfortunately, this bill usurps the Constitution. It presents a clear separation of powers issue. It also calls for various lower court judicial panels to review and rule on the actions of the one Supreme Court and its justices. So, can you imagine? Lower courts established by Congress would be tasked with policing the Supreme Court in ways our founders sought to avoid. In all of the hearings the Judiciary Committee has had on this topic, not one witness was able to articulate effectively how such measures would be constitutionally sound. The SCREET Act would create a roadmap for parties to seek out newly defined quote-unquote conflicts and recusals of processes. This could be abused to disqualify justices who may be unfavorable to the far left's view, especially on high-profile cases. This bill, as currently written, risks undermining the independence and the integrity of the Supreme Court. Chief Justice John Roberts, in his letter to Chairman Durbin, dated April 25th, included a, quote, statement on ethics, principles, and practices, end of quote. This statement, undersigned by all justices, reaffirms their commitment to upholding the integrity of the court. So that should also be submitted for the record of this committee. This was signed by all sitting justices. I'd also like to enter, I've already said that. This bill, if enacted, would bluntly insert politics into the Supreme Court and erode away at the checks and balances carefully crafted by our founders. This legislation may needlessly force us down a road towards constitutional crisis. Therefore, I'm not in favor of regulations of this legislation until we know whether the Supreme Court's own actions taken on March the 7th to clarify its disclosures is sufficient. In other words, considering this legislation's probably, even if it should ever be considered, a year or two till we find out how the new regulations work out. Just like each member of Congress and the White House, the Supreme Court ebbs and flows across the ideological spectrum. During the 1930s, scholars have described the Supreme Court as a conservative court. Meanwhile, during the 50s and 60s of the 1900s, the Warren Supreme Court was much more liberal. Someday, this court will shift again. But the actions being considered today are a result of a temper tantrum by the far left. The left dislikes certain recent Supreme Court decisions and are unable to unilaterally ram their policy proposals through the Congress. These efforts to hijack the Supreme Court must stop. Chief Justice Roberts, in his concluding paragraph of Biden versus Nebraska, cautioned against visceral rhetoric and baseless political hits against the court, which has undoubtedly come to a boil in the last several months. So Robert notes, quote, "It's become a disturbing feature of some recent opinions to criticize the decisions with which they disagree as going beyond the proper role of the judiciary. Reasonable minds may disagree with our analysis. In fact, at least three do. We don't mistake this plainly heartfelt disagreement for disparagement. It's important that the public not be misled either. Any such misperception would be harmful to this institution and our court and our country. The end of Robert's statement. Before I yield back, I'd like to enter in the record another Wall Street Journal article from June 21st titled, quote, "Ethics and the Supreme Court Independence," end of quote. This article also highlighted the details, some of the constitutionality, judicial independence, and balance of power concerns of these legislative principles put forth so far. I yield.
Thank you, Senator Grassley. Senator Grassley has asked that several documents be entered into the record with unanimous consent, and without objection, that will happen. I also ask unanimous consent to enter into the record a letter of February 13th, 2012, signed by 5 members of the Senate, including 3 current members, myself, Senator Whitehouse, and Senator Blumenthal. The letter, of course, is addressed to Chief Justice John Roberts on the issue of a code of conduct and ethics for the Supreme Court. The date again was February 13th, 2012. Now I'm going to recognize those members seeking recognition, and then we'll move to amendments. Senator Kennedy is on the list. Senator, you're next.
Thank you, Mr. Chairman. It would not be difficult, I think, to sit here and pick apart this legislation. And I think my Democratic colleagues know that. There's not a dummy among them. There's not a dummy on this Judiciary Committee. But you don't have to be Oliver Wendell Scalia to figure out that this legislation is meant to be a court-killing machine. For example, it would allow any jackaloon out there in America in a tinfoil hat whose own dog thinks he's an utter nutter to file a motion to recuse the United States Supreme Court Justice. Now, what could possibly go wrong? What could possibly go wrong? And my Democratic colleagues know that. So I'm not going to go too far down that road. Number 2, this bill is dangerous, but it's unserious. And I think my colleagues, some of them know that, and they're trying to make a point. One of the reasons I'm proud to be a senator is because I believe every person in this body, Democrat and Republican, loves this country and loves our institutions and wants to protect them. And I say that because while I'm upset with this bill, I would be more upset if my Democratic colleagues were trying to move it when they have the votes. Now, they don't have the votes. You got the votes to get it out of here. But this thing's dead as fried chicken on the Senate floor, and it's dead as fried chicken in the House. And maybe I'm naive, but I believe in my heart of hearts that if you did have the votes and you could pass this bill, which we all know would destroy the United States Supreme Court as an institution, you wouldn't do it. Maybe I'm naive. It's still a dangerous bill. Final point. Look, this bill's not about ethics. If we want to have a debate about ethics, I'm ready. This bill is, and we all know it, the press knows it, this bill's about the Groff case, the Alinas case, the Harvard case. It's about Dobbs. It's about Bruin. It's about West Virginia versus EPA. We all know what a tell is. Even if you've never played poker, you know what a tell is. A tell is behavior that gives unintended information about what you really think. There are plenty of tells about what this bill is really about. I still can't get over, Mr. Chairman, that he said it. I still can't get over that Senator Schumer went to the steps of the United States Supreme Court and said the following, and I'm going to quote him because it gives me chills of the wrong kind. Senator Schumer said, quote, "I want to tell you, Gorsuch," not Justice Gorsuch, Gorsuch. "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions." Oh, my God. And later, the next day, our colleague had a chance to fix his remarks on the Senate floor. Here's what he said, quote, Senator Schumer said here, right, it's in the record, there would be political consequences. Political consequences for President Trump and Senate Republicans if the Supreme Court with newly confirmed justices stripped away a woman's right to choose. What bigger tell do you want? Some of my colleagues on this committee, as is their right, signed off on an amicus brief to the United States Supreme Court. As you know, when you submit an amicus brief, you're trying to persuade the court on the basis of logic and law to decide in a particular way. It's not supposed to be a political document. This is what some of my colleagues said in their brief. Quote, "It's another tell." Quote, "The Supreme Court," this is in a brief to the United States Supreme Court. Quote, "The Supreme Court is not well, and the people know it. Perhaps the court can heal itself before the public demands it be restructured in order to reduce the influence of politics, particularly on the urgent issue of gun control. A nation desperately needs it to heal." That's what this case is all about. This bill's all about. And I get it. You disagree with opinions of the United States Supreme Court.
Will the senator yield for a question?
No, I will not. Oh, I'm sorry, Senator Cornyn.
Yield for a question?
If I could finish my thought.
Senator, I think
That's a tell.
That's a
Yeah.
tell.
I thought it was Senator Blumenthal. If I could just finish my thought, Mr. Chairman. I get it. You disagree with Bruen. You disagree with Dobbs. I get it. The answer is not to destroy the Supreme
Will
Court.
the senator yield for a question?
I will not. I get it. But the way to change a ruling of the Supreme Court is to go find the right case and persuade them. And that's my final point. I appreciate it all the time. Now I'll yield.
The senator is aware that there was an assassination attempt on a sitting Supreme Court justice, Justice Kavanaugh. You're aware of that, certainly.
Yes.
Do you have an opinion about what the impact on an unstable mind might be when the majority leader of the United States Senate stands up in front of the Supreme Court of the United States and makes a threat against the court? What the impact might be on an unstable mind?
Well, it could be, I'm not a psychiatrist or a psychologist, but I think all of us have common sense. I think it would be extraordinary. And I think all this heated rhetoric about ethics, about Clarence Thomas being an Uncle Tom. I mean, come on. I think it just destroys the institution. And again, this bill isn't going to pass, and I think we all know that. And I still believe my Democratic colleagues, if they had the votes, wouldn't bring it. Just like if we got down to it, they wouldn't get rid of the filibuster. They wouldn't get rid of the blue slip. We've given away enough power. I get why they have to advocate for it, but when it came down to the lick log, they wouldn't do it. But all this rhetoric has consequences. That's my only point.
Political violence in furtherance of any cause is unacceptable. That is a bipartisan position of this committee, and I hope it was very clear. I've repeatedly condemned all violence and threats of violence, regardless of whether it comes from the right or left and whether it targets election workers, judges, even Supreme Court justices. Last year, Congress passed the Supreme Court Police Parity Act and the Daniel Anderl Judicial Security and Privacy Act. These bills took important steps to protect the federal judiciary and their families, including the justices of the Supreme Court. Protecting the judiciary has always been a bipartisan issue. That said, unfortunately, passage of the Daniel Anderl Judicial Security and Privacy Act was delayed for nearly 1 year because of repeated objections by a single Senate Republican, not a member of this committee. The Supreme Court Ethics, Recusal, and Transparency Act allows for both judicial transparency and security by including protections to prevent disclosure of private or sensitive information. We can protect public officials while also ensuring that they are performing their duties in an ethical manner. If no one else seeks recognition, the floor will be open for amendment. Senator Cornyn.
Thank you, Mr. Chairman. I can't improve on the statement of Senator Kennedy, but I do want to just add a few thoughts before we get to the amendment process. I can't help but believe that this is just another episode in a long-standing campaign of intimidation and harassment of the Supreme Court and its members. Not that long ago, we had a hearing where I played the video of Justice Clarence Thomas's confirmation hearing when he referred to the attacks, the false attacks against him as a high-tech lynching. The reason I thought it was important to play that is because that happened a long time ago, and many people may have forgotten, or they may not know about the long-standing campaign of harassment and intimidation against the court. The most recent one is the whirlwind threat by the Majority Leader of the United States Senate. But it didn't start there. It started a long time ago. Justice Scalia liked to say that the United States is unique because of its independent judiciary. A lot of other countries have a parchment constitution. The old Soviet Union had one that read pretty well on paper. But without an independent judiciary, the rights and liberties of the people will not be preserved. They'll be dictated by whoever happens to be in power at the time. Now, some of the threats against the judiciary are overt, like the Senate Majority Leader. Others are more subtle or covert, like the letter that was sent by members of this Judiciary Committee and asked to defund the Supreme Court of $10 million if the Chief Justice did not put into effect a public code of ethics for justices of the court. That's a threat. It's not as bad as what Senator Schumer said, but it's a threat against the independence of the court. You do it my way, or we're going to cut your budget. I don't think it's any secret that our public institutions are under assault, all of our public institutions. And I would just ask for us to think just a moment about what this bill and this campaign of harassment, intimidation directed toward the Supreme Court, what that's doing to public confidence in our independent judiciary and most cherished and unique institutions. I used to be a judge for 13 years on the trial bench and the state Supreme Court, a total of 13 years as a judge. Judges have codes of ethics, just like the Senate has a code of ethics that is administered by an ethics committee. And we all understand how that process works. But I dare say that if the Supreme Court decided they didn't like the ethics code or the way the Senate Ethics Committee administered that ethics code, I dare say if the Supreme Court sent a letter over criticizing it or suggesting changes, I don't think any of us would take that seriously. Conversely, the Supreme Court and the judiciary is a co-equal branch of government. I can't help but believe that this long campaign of intimidation and harassment is designed not to treat it as a co-equal branch of government, not to build and maintain public confidence in some of our most important institutions, but rather to make it subservient to the will of Congress. You know, it used to be that the organized bar, the American Bar Association, or in my state, the Texas Bar Association, viewed it as their professional duty to defend the judiciary. Because judges cannot. They can't defend themselves. They're not a political branch of government. Now, when somebody attacks us or our opinion, that's part of the bargain. And we can take to the airways, we can take to the floor of the Senate, we can take to social media, we can defend ourselves. But the Supreme Court and the judiciary cannot, by the nature of their job. So it falls to other responsible people to defend that institution, that unique institution which makes us different from literally the rest of the world. And I have no doubt, as Senator Kennedy alluded, that if the Supreme Court in its last term had decided a bunch of cases the way that our folks on the Democratic side liked, we wouldn't be having this hearing. We wouldn't be seeing all these attacks against the justices, the threats, the intimidation. You'd be just fine with it, as long as it's going your way. But the price we pay for an independent judiciary is we're not always going to agree with the decisions made by the judges. I think it was Robert Jackson who said the Supreme Court's not the Supreme Court because it's always right, it's final because they're right because they're final. I botched that paraphrase, but you get the point. Our colleagues on the Democratic side of the aisle appear to be determined to cast the independent judiciary and the Supreme Court as just another political branch of office. That's why they talk about packing the Supreme Court at one point. Ruth Bader Ginsburg said, if anything would make the court look partisan, it would be that. One side saying, when we're in power, we're going to enlarge the number of judges so we would have more people who would vote the way we want them to. That's Ruth Bader Ginsburg, an icon among liberals and progressives. And what I worry about from the standpoint of the United States Senate, what do you think is going to happen when the shoe's on the other foot? You know what happens? We tend to sink to the lowest common denominator, and we also tend to operate based on precedent. So if the precedent is established here, do you know what the temptation is going to be like when the shoe's on the other foot? It may well prove to be irresistible. We saw that when Harry Reid decided that instead of the 51 votes that were required to confirm a judge, that all of a sudden the requirement was for 60. And our Democratic colleagues filibustered judge after judge after judge. Well, it only took us 10 years or so to turn that precedent around. But I would just appeal to our colleagues who care about this institution among our other important institutions. What's being proposed here today is not just a code of ethics. The Supreme Court has one. The federal judiciary has one. It's not perfect, just like I'm sure there's a code of ethics that applies to senators that people don't like. Some of our colleagues have suggested, for example, we eliminate the ability of senators to trade in stocks on the stock market, for example. That's a debate we can have among ourselves, and we should. But our code of ethics isn't perfect either, but we're not going to welcome the idea of the Supreme Court sending us over a checklist of things that we should change as a co-equal branch of government. I don't think we're going to change a lot of minds here because the political forces have lined up. Either you're opposed to some of the decisions that the Supreme Court has made recently, or you accept them. And I think we all should be in a posture of accepting them, even if we don't like them. That's the price we pay for an independent judiciary. That's why judges have lifetime tenure. That's why judges' salaries cannot be reduced during their term of office. And I think our founders are rolling in their grave when they see how much the United States Senate and some of its leaders, including the majority leader, have engaged in this long campaign of intimidation and harassment and undermined public confidence in one of the most important institutions in our government.
Now we have two members who sought recognition, Senator Feinstein and Senator Lee. Senator Feinstein.
Thanks, Mr. Chairman. This bill, I believe, is going to strengthen the ethical standard, financial disclosure requirements, and recast that improve the court in some of the ways I'm going to try to express. The Supreme Court today is the only federal court in the country that's not governed by a code of ethics. Currently, when Supreme Court justices recuse themselves from a case, they are not required to explain how or why they are recusing themselves. This bill would strengthen the ethical standard, financial disclosure requirements, and recusal requirements that apply to Supreme Court justices. These changes include adopting a code of conduct for justices and establishing procedures to receive and investigate complaints of judicial misconduct. This bill will establish important ethical standards, if given a chance, for Supreme Court justices related to their financial disclosures and decisions whether to recuse from hearing a case. This bill is in line with efforts to improve ethics and disclosures and all federal government to ensure trust in our democratic system. The bill is not expected to have bipartisan support, unfortunately. I hope it does in this vote. I look at this as a major, major vote for me and for improvement of this body. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Lee.
I think it's easy for us to take for granted and overlook the extent to which we've all benefited from living in a country that operates under the rule of law. In order to have the rule of law, as opposed to the rule of individual men and women who serve within a government, you really have to have some kind of structural protection in place to protect the people against the risks with devastating consequences associated with the excessive accumulation of power in the hands of the few. It was for this reason that some of our leading legal thinkers, including, I remember 12 years ago when I first arrived in the Senate and came onto this committee, within a few months or so of my arrival, we had a couple of Supreme Court justices visit. Justice Breyer and Justice Scalia came to talk about the courts. As I recall, they did that from time to time. It was something I had seen before. I'd seen them do sort of this roadshow exercise in which the two of them would play off of each other, sometimes telling jokes at each other's expense, but always in a good-natured way. It was during one of those visits, and I believe it was in this very room, when Justice Scalia said something that has stuck with me. He referred to the fact that, along the lines of what Senator Cornyn was just describing a moment ago, in a lot of countries, there's a constitution. It might even be written on a single document like ours is. And it might even contain a Bill of Rights that looks really good. It protects most or all of the individual liberties that our Bill of Rights seeks to protect. In some cases, even lists more protections than ours does. But as Justice Scalia explained at the time, any tin-horn dictator anywhere in the world can have a Bill of Rights, and that Bill of Rights can look really good. By the way, I've never understood what the difference between a tin-horn dictator is and a regular dictator. He didn't explain, and he's no longer here for me to ask him. His point was clear. A lot of countries, including and especially those with tyrannical governments, have bills of rights. What he said next was intriguing. He said, what differentiates a Bill of Rights that means something from one that doesn't is a mechanism by which you can separate out power, allow power to check power, and thus protect the people from the dangers associated with the excessive accumulation of the power and of power in the hands of the few. A sine qua non of this really is an independent judiciary, a court system that stands separate, detached from the political operations of that government. Now, in our system, of course, we've got the three branches. We often refer to our branch, the legislative branch, together with the executive branch, headed by the president. We call those the two political branches. And by calling them that, we differentiate them from the court. The court, although it's populated by people who have to go through the political process, having been nominated by the president, confirmed by the Senate, once they're put in place on good behavior, they remain there for the rest of their lives, absent other circumstances. This really is an essential part of having an independent judiciary. And without the independent judiciary, there can be no rule of law. And it's easy to overlook all the benefits that we reap every single day as a result of that. We're known throughout the entire world as a country where the rule of law is a thing, where if you enter into a contract, there will be a mechanism by which the terms of that contract can be fairly interpreted and enforced and enforceable in a court of law. This is one of the reasons why businesses from countries all over the world want to do business in America. They're looking to invest overseas. They may not want to invest as much in some other countries as in the United States. In fact, they almost never would prefer, when faced between the United States and another country, in many circumstances, in many industries, they'd rather do business in the United States if they can, in part because of this reason. We've all benefited economically and otherwise as a result of this. But this system isn't free, and it's not self-perpetuating unless we consciously, deliberately choose to protect it. And protect it we must, because you can break it. This is legislation. It is a solution looking for a problem. And it's a solution looking for a problem. It's carried out in such a way that can make a whole lot of things a lot worse, and that would, in fact, accomplish something very different than the lofty descriptions that you're hearing from its supporters today. Look, if the sponsors of this bill and those who plan to support it, if they were truly interested in ethics and integrity within the Supreme Court of the United States, I think they would have conducted this debate and this inquiry in a very different way from the beginning. And I think we would be seeing some of those differences now. I think also that it's important to recognize that the Supreme Court of the United States does, in fact, have ethical standards. It does, in fact, have its own ethics rules that it supervises, that it oversees. We do, in fact, have a judicial conference that can and does look into these things to overlook them. Now, you'll hear from the bill's sponsors today, and you've heard some of this already, and well, those aren't nearly enough. They're not good enough. They're lax. It's basically a post-apocalyptic hellhole over there from an ethical standard viewpoint. This is utterly false. It's not true. It is objectively untrue. It's slanderous, and it's deliberately slanderous so as to undermine the credibility, the reputation, institutionally speaking, of the court and its justices. Or I correct myself, I should say some of its justices, and I'll get back to that in a moment. But they do, in fact, have ethical standards. And in fact, in many meaningful respects, those standards not only match up to those that we follow, in some meaningful ways, they exceed those that are binding on members of the United States Senate. For example, in the United States Senate, we don't have the same recusal standards that they do. One can be a soybean farmer or a tobacco farmer and a member of the United States Senate and still vote on bills relating to subsidies for soybeans or regulatory issues associated with tobacco. We don't have recusal standards there. There are other differences, but this is a good one to highlight. Some of these differences, you see, reflect differences in the role that we play versus the role that they play. So to look at theirs and say, oh, that doesn't matter, that it's not adequate, all hell is breaking loose over there. It's just not true. And it's deliberately, or at least recklessly, but I think deliberately deceptive. But look, this thing really would have played out differently if the sponsors of this legislation were truly interested in an even-handed way of enhancing integrity at the Supreme Court. There are glaring instances in which there have been activities undertaken by Justices Ruth Bader Ginsburg, Justices Ruth Bader Ginsburg, Sandra Sotomayor, Stephen Breyer, and others that raise some serious questions under the rules and standards that currently exist. Notwithstanding those, in all those examples, with one glaring exception, I don't think there's any of us in here who would credibly maintain or contend that any of those things, any of those issues related to the democratically appointed justices I just mentioned, or to that of Republicans, none of those things amounts to something that could or would or should result in impeachment, removal, criminal prosecution, or something like that. If those things arise, there are remedies to do that. There are ways that we can remove a justice who is engaged in a high level of wrongdoing. But that's not on the table here. This is part of why I maintain this is a solution in search of a problem, but it's a solution that would cause a lot of other problems. Because the solution that they propose is one that would completely remake, it would reinvent the Supreme Court. It would reinvent the litigation strategies that go into handling cases before the Supreme Court. You see, because if a person can just, by filing a document or making an accusation, trigger a review panel of lower court judges whose rulings it's the Supreme Court's job to review, and in many instances reverse, it won't be long if this becomes law before it'll be considered malpractice for attorneys practicing before the Supreme Court to fail to try to trigger through these aggressive mechanisms a recusal and to cast even more doubt on the credibility and institutional reputation of the Supreme Court of the United States. I think that's very, very unfortunate. This really will change the game, because in some of those circumstances, if this were to become law, they'd succeed. Especially in a politically charged case. They'd figure out a way to get one of these panels of lower court judges to order the recusal of this or that justice in order to inflict their own carefully designed Supreme Court for that moment. You know, when lawyers go to trial, they go through the process of jury selection. In most parts of the country, we call that voir dire. Only in Texas they call it voir dire. I don't really understand the difference in pronunciation, but Texans, they do things their own way. Each side gets their own opportunity to object to each juror. There are two kinds of challenges to a would-be member of the jury panel. You've got for cause challenges. You can challenge somebody for cause. You know, potential juror knows the defendant or the plaintiff, the prosecution or defense, or has some type of conflict, either side can challenge that and have that person removed from the jury panel. But the other kind of challenge is what we call a peremptory challenge. You can remove a small handful of jurors for almost any reason or no reason at all. It seems to me that this legislation would, in effect, treat the Supreme Court justices, approach them in almost the same way one might approach a potential jury, with the attorneys having the opportunity to remove individual justices whom they might consider problematic for their particular case. So at the end of the day, we look back at the fact that almost none of these instances really rise to the level of criminal wrongdoing or impeachment and removal. I don't see it. It's not there. Not on the Democratic appointees, not on the Republican appointees.
Senator,
I do, however, see one of them.
Senator, if you could wrap up, we have the other committee meeting now, and
I understand that. I've got things to say on this, and we have always allowed members to
all members
speak.
have it. No, I hope all members have a chance to do that.
Oh, okay. I will wrap up with all deliberate speed.
What about your chart?
I'm getting to that in just a moment. There is one exception that I'm talking about. There is one allegation that's come to light fairly recently with regard to the late Justice Ruth Bader Ginsburg. Now, Justice Ginsburg, while I disagree with many of her rulings, she's someone for whom I've long had deep respect, but there are some very serious allegations that have recently come to light that I've recently become aware of, to the effect that she received a $1 million award that went unreported. Now, I'm still reserving judgment as to exactly what to make of that. That's the only one of them that I would say, yeah, that one this might have some very significant ramifications. If she were still serving on the court, if she were still alive, that might lead to something. Even there, I feel the need to qualify that because I don't yet know all the facts of it. Those haven't all come to light. We don't yet know exactly what was done with that, whether she carried out the apparent intention or the stated purpose of intent at the outset to donate it to charity. There's a lot we don't know there. But that's an example of something that could be more significant. The other things that we're talking about are not things for which anyone in this room could credibly maintain is the stuff of impeachment and removal. So, look, I've got colleagues on this committee on the Democratic side who like to talk a lot about dark money on the right. But let me tell you a little bit about how liberal dark money is funding these activist hit pieces underlying this legislation and the perceived need for it on the left. These activist hit pieces written by ProPublica, while also funding the activist groups calling for court packing and supporting this legislation openly, actively, aggressively gunning for it. This is the same ProPublica that publishes hit pieces on Justice Thomas and on Justice Alito, while simultaneously turning a blind eye to other conduct from those justices appointed by Democrats. Even and especially a $1 million award given to a democratically appointed justice. Look, this chart details some of this about the Sandler Foundation launched by ProPublica. The Sandler Foundation, rather, launched ProPublica and remains ProPublica's largest donor. Now, the Sandler Foundation also funds the Campaign Legal Center and the American Constitution Society, known in the industry as ACS. Both organizations publicly called for the investigations of Justice Thomas, shortly after ProPublica's hit piece on Justice Thomas. These hit pieces cited experts from the Campaign Legal Center and from ACS. The Sandler Foundation also gave money that Arabella Advisors' New Venture Fund had earmarked for Demand Justice, which, as many in this room know, is an organization that advocates for court packing and has openly and aggressively called for Justice Thomas's resignation from the court. The Silicon Valley Community Foundation gave money to ProPublica and Citizens for Responsibility and Ethics in Washington, or CREW. CREW sent a letter to Justice Thomas calling on him to resign. The Marisala Foundation also gave money to ProPublica and to CREW. George Soros' foundation to promote open society is donated to ProPublica, the Campaign Legal Center, and CREW. The William and Flora Hewlett Foundation is given to ProPublica, the Campaign Legal Center, the American Constitution Society, Alliance for Justice, and Fix the Court. And the Ford Foundation has funded the Center for Popular Democracy and the National Women's Law Center. Both organizations called for Supreme Court reform based on ProPublica's reporting. I will close by winding back for just a moment to the whirlwind. The whirlwind quote raised by Senator Kennedy just a few minutes ago. What was that whirlwind? What was Chuck Schumer saying on the Supreme Court of the United States steps that day? He stood on the steps of the court. We will unleash the whirlwind. You won't know what hit you. Justice Gorsuch, Justice Kavanaugh. Actually, I think he just said Gorsuch and Kavanaugh, leaving out their titles. What was it? Was the whirlwind the guy who traveled great distance and arrived at night outside the home of Justice Kavanaugh to kill Justice Kavanaugh? Was that the whirlwind? Was the whirlwind the blatant refusal to enforce 18 U.S.C. 1507 as against those terrorizing, sometimes daily, often weekly, or on some other semi-regular basis, the families of Supreme Court justices by protesting outside their homes, allowing those protests to take place, and then refusing to enforce federal law that makes that unlawful to do that at the home of a Supreme Court justice? Or was it these attacks impugning the credibility and character of jurists who have worked a lifetime to build reputations for themselves, reflecting on the court of credibility, even-handedness, and fairness? Perhaps that was the whirlwind. If so, this is part of that whirlwind, and we must defeat it. Thank you.
Thank you, Senator Lee. In defense of Ruth Bader Ginsburg, who cannot defend herself, she disclosed the $1 million award and then announced she was donating it to charity. I might also add that any provisions in this bill before us apply equally to every single member of the Supreme Court, whether they are appointed by a Democrat or Republican, conservative or liberal. Now we are going to consider amendments. Senator Graham, I believe you have the first amendment.
Yeah, thank you, Mr. Chairman. I have an amendment that, building off what Senator Lee said, Section 1507 of our federal code makes it a crime to picket and go to homes of Supreme Court officials or judges and in a way to keep them from being intimidated and harassed. I think all of us on this committee, it's 23892 is the amendment, SIL 23892. Okay. So I remember very vividly that, protesters came to my house, somebody broke a window. Not a pleasant experience. Appreciate the Capitol Hill Police helping me out there. I A lot of us probably had people come to our homes during the Kavanaugh and other events. That's sort of uncomfortable. I know we got some members here with small children. Got to be sort of a better way. So Section 1507 is on the books. And as Senator Lee said, very organized effort to intimidate justices, some with small children. Basically, nothing happened to anybody. You can be sympathetic to their cause, but we should also enforce the law no matter how we feel about the cause. No matter how I feel about what you're doing, I don't want anybody to go to your house and break your window. No matter how I feel about your legislative agenda, I don't want anybody to threaten you and your family. That's just not good for the country. So this amendment will allow the Supreme Court police, who have limited authority, to investigate violations of Section 1507. The Justice Department, for some odd reason, basically gave everybody a pass, and I can only imagine how uncomfortable it was for the justices, some with small children, having to endure this. So the Supreme Court has a police force designed to protect them and the grounds, and it does have limited jurisdiction, but the point is that I'm glad the Supreme Court has its own police force. Seems like to me they're going to need them now more than ever. So I'd like to have an amendment to amend to allow the Supreme Court police to investigate violations of Section 1507, a statute designed to protect the court and their homes.
Before recognizing other members, I'm advised by my staff that this amendment would add responsibilities to the Supreme Court police, which I believe you said, tasking them with investigating violations of the federal prohibition on picketing or parading with the intent of interfering with the administration of justice or influencing a judge in the administration of their duties. Judicial security has consistently been bipartisan. As I mentioned earlier, we passed legislation to protect the federal judiciary and their families, including justices of the Supreme Court. Each year, the Supreme Court is visited by an estimated 500,000 visitors from around the world. The Supreme Court police are responsible for protecting the visitors as well as the justices and their staff. Expanding their responsibilities to investigate picketing and protesting may stretch their resources beyond their current assignment. I don't know how much it will cost or who will be given the assignment, but it currently is the responsibility of the Department of Justice, the FBI, and local law enforcement to do that. To move that responsibility to the Supreme Court police raises questions about their capability and resources. We can all agree judicial security is of the utmost importance, but the bill today is about another issue completely different. It is about protecting the reputation of the Supreme Court by ensuring that justices create an enforceable code of conduct. If my Republican colleagues will join in my concern about protecting the justices, it would be refreshing if they would join Democrats in supporting the appropriations legislation that funds Supreme Court security. The fiscal year 2023 omnibus bill contained millions of dollars in such funding. Unfortunately, 7 Republican members of this committee voted against this bill to provide that funding to protect the Supreme Court. I urge my colleagues to oppose this non-germane amendment. Senator Senator Graham.
Thank you, Mr. Chairman. If I may, I would imagine that some of the members of this committee who voted against the appropriations bill probably didn't do it for that reason. That's what happens when you, at the end of the year, you throw everything in a big pot and you can't have a normal process. So it puts a lot of our members in a bad spot. And I'm hoping we'll go to Appropriations Committee here in a minute and try to clean up that mess. But here's what I'm saying. The system failed. The system designed to protect justices at their homes failed. The Department of Justice failed. The people in charge of enforcing the law under 1507, in my view, failed. I'm not taking power away from them. I'm trying to give power to the police who protect the Supreme Court to investigate intimidation of the court in their homes. I regret I'm having to do this. I never thought I'd have to do this. But if you don't see the failure, then you're blind. The people who came to picket these justices had a desire to intimidate them, make their life miserable, and we have laws on the book preventing that. Nobody's been held accountable. So let's allow the police department, who has direct authority over the protection of the Supreme Court, the power to investigate. And if they need more money to hire investigators, I am sure that we can find a way to do that. So the idea that this giving the power to investigate intimidation of justices in their homes somehow makes justices less safe makes no sense. None. And the reason I'm doing this is because the system failed, and we need to change that system.
Anyone else
Mr.
seek
Chairman,
recognition?
Mr. Chairman,
Senator Feinstein and then Senator Klobuchar.
Thank you, Mr. Chairman. I'm going to vote no. The amendment, I believe, is not germane to the issue of Supreme Court ethics addressed in this bill. It would give the Supreme Court police the authority to investigate a federal crime that is already under the jurisdiction of the United States Department of Justice, which could create jurisdictional concerns. The Justice Department and the FBI already have responsibility for investigating these crimes.
Thank you. Senator Klobuchar?
Mr. Chairman, I have some sympathy for this issue and for the fact that we are not doing enough when it comes to security. I'm pleased about the bills that we have passed. I believe that we need to do more. I think many people in this room, as noted, have had some pretty bad experiences with security. I'm going to vote no simply because it is not what we're focused on today, which is the ethics of these justices and trying to put some ethical rules in place that I wish very much the court could more clearly do themselves with an enforcement mechanism. I think we all know this isn't the first time Congress has stepped in to make sure that our government officials behave ethically, but I am happy to work with my colleagues in the future on this issue because I believe we have neglected our own security as well as others, and no one does anything about it when they have their own security, and then for those of us that don't, we just get stuck with it.
Thank you. Senator Welch, do you seek recognition on this amendment?
I do. I had hoped to just make a comment about the bill, but I'll do it in the context of this amendment if that is okay, and I'll be brief. I listened very carefully to some of the very important concerns that my colleagues on the Republican side raised about the independence of the judiciary, the separation of powers, the politicization. Those are all things that are of great concern to me. The rule of law really matters. But I kind of took a poll from Vermonters. I live on a dirt road and checked with some of my neighbors, and I asked a simple question. Do you think that a justice should be required, if they receive private airplane travel in yacht vacations, be required to disclose it? And they looked at me like that was the weirdest question they'd ever heard. And they didn't answer it. They asked me a question. They said, they can do that? Seriously? And I didn't have an answer for that. So the heart of the bill here is about it disclosing something that the vast majority of the people we represent, all of us, think shouldn't be done in the first place. So disclosure is the bare minimum. And that has to apply to anybody who's a judge, appointed by Clinton, appointed by Trump, appointed by Biden. Everybody should have that obligation. So this is like the minimum, and it has, in my view, very important implications for trying to restore credibility to a Supreme Court that's not held in high regard right now. And it's been a big disappointment to me to see the failure of the Chief Justice to not act and essentially put this in the court of this Senate Judiciary Committee. I yield back.
So the questions on the adoption of the
Mr. Chairman, if I
Senator
may
Graham?
respond. Senator Welch, in I think it was March, April of this year, the Supreme Court dealt with this issue. They now require disclosures of trips on private planes, boats, et cetera. They've already done this.
Questions on the adoption of the Graham Amendment, SIL 23892? The clerk will call the roll.
Mrs. Feinstein.
No.
Mr. Whitehouse.
Nope.
Ms. Klobuchar. No. Mr. Coons.
No by proxy.
Mr. Blumenthal. No. Ms. Sorono. No. Mr. Booker. No. Mr. Padilla.
No by proxy.
Mr. Ossoff. No. Mr. Welch. No. Mr. Graham.
Aye.
Mr. Grassley.
Aye by proxy.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz.
Aye by proxy.
Mr. Holly. Aye. Mr. Cotton. Aye. Mr. Kennedy.
Aye by proxy.
Mr. Tillis. Aye. Mrs. Blackburn. Aye. Chair Durbin.
No.
Chair Durbin, on this vote, the ayes are 10, the nays are 11.
The amendment is not agreed to. Any further amendments to come before the committee?
Mr. Chairman, we have 61 amendments that I know of, so we can do it any way you'd like. We can do it by seniority, or people can be recognized, but I do believe every amendment deserves to be debated and voted upon. So I think, Senator Cornyn, would you like to offer an amendment?
Yes, Mr. Chairman, if I can be recognized.
Senator Cornyn.
Mr. Chairman, I'd like to call up my amendment OLL 23707. This would extend the right to carry a firearm to federal judges so they can protect themselves. Many of us, back in Texas and also here in D.C., have gone through the process of getting a concealed firearms license because I'm concerned, particularly with the increase in crime and attacks against public officials and threats against public officials, that they need to be in a position to defend themselves should they choose to do so. We've already talked about the high-profile threats and attempted attacks against Justice Kavanaugh, but of course, we know there's also been a recent killing of a retired Wisconsin state court judge, John Romer, by a criminal who'd previously sentenced him. And of course, we've also considered the tragic death of Judge Salas's son in 2020. So I've heard from a lot of judges, not just on the Supreme Court, but across the country, who are reporting more and more threats of violence against them. Judges should be able to protect themselves and their lives and their family members anytime, anywhere, whether or not a police officer answers a 911 call on a timely basis. So my amendment would allow those federal judges who choose to do so the authority to, along the same terms as qualified law enforcement officers do now. This is particularly important as federal judges go to and from their federal courthouse, travel, or even run errands in their neighborhood. I urge my colleagues to support the amendment.
Thank you, Senator Cornyn. As I understand it, there's nothing to stop a federal judge from carrying a gun now other than state and local law. And I don't know if this is an attempt to exempt
There's
federal,
nothing to stop them other than state law or federal law.
state and local that I can think of.
So well, the point is this would make it under federal law, which would preempt restrictions at the state and local level.
Does that require a training course?
That's voluntary by the judge.
Well, it raises some
They're
questions.
trained sportsmen. They've been raised their whole life using firearms. They know how to do so safely and store them appropriately. I think if we trust them with our Constitution, we should trust them with a firearm to defend themselves.
Nothing under current law that prohibits a federal judge from applying for a concealed carry permit wherever he happens to reside. Nothing. I don't know if this is a federal preemption of state requirements on training, and each state has a different approach to this, but I certainly wonder why we would take this up at this moment when we're considering protecting the reputation of the court. I would
Well,
oppose
because of
this
the
amendment.
overt attacks by the majority leader of the United States Senate and others. I mean, Mr. Chairman, you pointed out appropriately so, we have responded with additional resources for law enforcement.
And we will continue to.
For the members of the court. And I asked Senator Lee because I wasn't sure that was the case, but apparently there are protective details available to the justices now, but historically that's not been true. They've been basically on their own or on an ad hoc basis when they've requested the U.S. Marshal Service to provide them assistance. But the premise that the Supreme Court, like many other public officials, are subject to threats and potential attacks against their person or their families, I don't think is in doubt.
Anyone else seek recognition on this amendment? If not, the clerk will call the roll.
Mr. Chairman.
Senator Hirono?
Mr. Chairman, this amendment, like the previous amendment, are among a number of amendments, over 60, filed by our Republican colleagues on this committee, which has nothing, as far as I can see, to do with a code of ethics for the Supreme Court. So now suddenly we're dealing with an amendment that would allow justices and judges to carry guns. What does that have to do with a code of ethics for the Supreme Court? I have to say that sitting here listening to my Republican colleagues malign our motives as to what we are attempting to do with something, as I thought, as common sense, as requiring the Supreme Court to abide by a code of ethics as all of our other judiciary members have to abide by. What is so hard to understand about that? In the meantime, I see there are other amendments that have to do with our code of ethics, the executive branch behavior, members of the Judiciary Committee. You know, I don't know what that has got to do with the matter and the bill before us. So I'd just like to say that, in addition to what I've already said, first of all, it is not productive to question really the motives of those of us who sit here and who are saying that the highest court in the land should be setting an example in terms of abiding by a code of ethics. So we do not often see sitting judges, weighing in on the need for the Supreme Court to have a code of ethics. So I would like to ask unanimous consent to have Judge Michael Ponzer's article. It was a guest essay in the New York Times dated July 14th, 2023. And when she says, yes, does the Supreme Court realize how bad it smells? And in the context of the various disclosures, that raises a lot of eyebrows, you know, free private airplane travel, payment of tuition. And yes, this applies to Republican and Democratic nominated Supreme Court justices. So in the end of his article, he says, although the exact numbers fluctuate because of vacancies, the core of our federal judiciary comprises roughly 540 magistrate judges, 670 district judges, 180 appeals court judges, and 9 Supreme Court justices, fewer than 1,500 men and women in a country more than 330 million people and 3.8 million square miles. And much depends on the small cohort's accurate sense of smell, its instinctive, uncompromising integrity, and its appearance of integrity.
Mr. Chairman?
So I will be voting against this and other amendments that have nothing to do with what is before us, which is Code of Ethics for the Supreme Court.
Without objection, the article referred to by Senator Hirono will be added to the record. Senator Graham?
Yeah, Mr. Chairman, I'd like to respond to my colleague from Hawaii. The point we're trying to make is that we're not questioning motives. We're reading what you said. We're putting this in context of a broader picture. The majority leader of the United States Senate went to the steps of the Supreme Court and threatened them as much as you can literally threaten somebody. There's been an effort on your side to expand the Supreme Court, to do away with the conservative majority. So there's a pattern here of trying to diminish, demonize, and neuter the court. I don't know if you've read the bill you're supporting, but this bill is a complete frontal assault on how the court operates by congressional statute. It creates a system that Senator Lee described that would make it very easy to make an allegation of a conflict of interest and have a panel of judges, not the individual judge, decide the merits of this. It fundamentally changes the recusal system. At the end of the day, I think it is literally a remaking of the court designed to dilute the power that exists today of the Supreme Court for political purposes. And this can't be viewed in isolation. You know, Justice Ginsburg, a lot of Americans admire, including me. She got $1 million. I'm not suggesting she took the money. I think she gave it away, but she won't tell us who she gave it away to. And they still won't.
Mr. Chairman.
She signed an opinion, the Virginia Miller Institute VMI case about women going to state-supported schools. She signed a copy of that opinion to be auctioned off by the National Organization of Women's Legal Defense Fund. So all I'm saying, and the court travels everywhere. I have not bored this committee with the travel schedule of all the justices during the summer, and I don't begrudge them for doing that. I wish I could go to some of these places. The bottom line is, you know, I'm not begrudging that. You are trying to destroy this court, and this bill is part of a process. So yes, we view this in a broader context. These amendments have everything to do about protecting the court. Millions of Americans watched on television an organized effort to go to Supreme Court justices' homes for the desired purpose of ruining their lives, intimidating their families, and not a damn thing happened about it. Yes, that is, to me, relevant. Whether a judge should carry a gun or not, if they want to, they should. The bottom line here is this is relevant. And we will look at this in a broader perspective. And that perspective, I think we've tried to articulate pretty well. A concerted effort been going on for years to marginalize and destroy this court.
Mr. Chairman,
Senator Hono, and then we'll call the vote.
Since my colleague is directly addressing me, I would like to say that if there's anybody that's been spending decades trying to put onto the Supreme Court the kind of people who have an ideological agenda, I would say that it is the very judges or justices that my colleague is supporting. So again, I say that we are confronted with a Supreme Court that in terms of recusal, for example, they get to decide individually whether or not they will recuse themselves. How is it that you can have a Supreme Court justice who does not recuse himself when his wife is involved in the very issue that is before him? I would say that those kinds of examples really raise the question of why shouldn't the Supreme Court have a code of ethics as those kinds of provisions apply to everybody else. And by the way, we have a code of ethics in the Senate. This is our code of ethics, Senate Code of Ethics. Why shouldn't the Supreme Court, which is the highest court in the land, and when you talk about intimidating the court, how do you intimidate the court that gets to decide cases and reverse cases that are decades-long decisions, and there's nothing we can do about it? So please, the constant refrain of citing to the majority leader is, as in my view, it's not very compelling. What is compelling is the need for the Supreme Court to have a code of ethics.
Chairman.
Thank you, Mr. Chairman. Let's get to the vote.
Senator Cornyn?
Mr. Chairman, I would just direct the senator from Hawaii to the United States Court's website, which has a code of conduct for U.S. judges. You said they don't have a code of conduct and they need one, and so the Congress has to impose it on them. That's just factually incorrect. And the senator's question, what's the relevance of providing a judge an opportunity to defend themselves and their family? What's the relevance of that to the longstanding campaign of intimidation and harassment? recently rising to the crest of the majority leader threatening two members of the court by name. You know, what's the relevance of self-defense to that? Well, it is because there are unstable minds out there who, when they see public officials accusing the members of the court of wrongful conduct, they will respond to that. And thank goodness, in the case of Justice Kavanaugh, law enforcement was able to interdict the individual who intended to kill him. So I think Justice Kavanaugh and every judge ought to have the ability to defend themselves if other defenses are not available. And it's directly related to the campaign of intimidation, harassment, and the attempt to politicize the court.
Mr. Chairman, I'd like to make
Question is on the, Senator Lee.
Yeah, as to the recusal standard, yeah, they make that decision. That is how that works. It's how it's always worked. It's how it should work. It's no different in that regard from what we have in the United States Senate. We also have the decision up to us as to whether to recuse. The difference is there's no legal expectation or requirement that we do so. They do have one. Thank you.
Questions on the adoption of the Cornyn Amendment OLL 23707. The clerk will call the roll.
Mrs. Feinstein.
No.
Chair Durbin.
Aye. No.
Chair Durbin, of this vote, the ayes are 10, the nays are 11.
The amendment is not agreed to. Any further amendments?
Mr. Chairman,
Senator
I would like to
Blackburn.
call up Amendment SIL 23875.
Senator will please explain her amendment.
Yes, thank you, Mr. Chairman. This deals with the leak of the Dobbs opinion. And to so many Tennesseans, that was truly a low point of the court. Now, confidentiality and trust of the court, this is something we've talked about a good bit, how important that is to the deliberative process. And Justice Thomas said, when you lose that trust, it changes the institution fundamentally. And that leak really put a spotlight on the efforts of some from the left to push forward their agenda. They went so far as to accuse Justice Alito of leaking the draft. And the American people knew that that was unlikely. The leak didn't just harm public confidence in the court, it literally made the justices targets. A target of assassination, children became targets. No member of the U.S. Senate should be okay with that type targeting of our justices. Now, this amendment is simple. Since it seems that my colleagues on the other side of the aisle are intent on pushing through this effort to delegitimize the Supreme Court, my amendment delays the implementation of this bill until the Dobbs leaker is identified and publicly disclosed. This ought not to be a hard vote. Mr. Chairman, even yourself, in January, you said, and I'm going to quote you, the leak of the majority draft opinion in the Dobbs case was an unacceptable breach of the Supreme Court's confidentiality and trust. So I am going to urge my colleagues to vote yes on this amendment.
Thank you, Senator. This amendment would tie the enactment date of Supreme Court ethics, recusal, and transparency to the date on which the person who leaked the draft decision in Dobbs is identified and publicly disclosed. I hope we can all agree, as I said earlier, that the leak of the majority draft opinion was unprecedented and an indefensible breach of Supreme Court confidential deliberations. However, I'm disappointed that the Supreme Court's own investigation, ordered by the Chief Justice Roberts, into the breach failed to uncover the source of the leak. I'm especially disappointed the investigation did not include sworn interviews for the justices themselves. They said they've gone to every possible person, but they stopped short of asking for sworn statements by the justices themselves. If anything, this highlights the need for more independent oversight of the court. However, this amendment would do nothing to address this failure, nor address the failure of the crisis of public confidence in the court. We're in a situation, Senator, where you're saying justices who have not given sworn statements can withhold those statements, whether they're implicated or not, go unresolved as to what the source of the leak was, and as long as that's the case, no code of ethics in the Supreme Court. I don't follow your thinking on this, and I oppose this
Oh,
amendment.
Mr. Chairman, I think that that it makes perfect sense that we would withhold this until they come forward with this information. This is something that we want to know. It is something that the American people want to know. So we should hold this bill, and even if it's signed into law, it would not be implemented until we find out who is the leaker and until that issue is resolved.
Question is on the adoption of the Blackburn Amendment, SIL 23875. The clerk will call the roll.
Mrs. Feinstein.
Aye.
No.
Oh, excuse me, no.
Mr. Whitehouse.
No.
Ms. Klobuchar. No. Mr. Coons.
No by proxy.
Mr. Blumenthal. No. Ms. Hirono. No. Mr. Booker. No. Mr. Padilla. No. Mr. Ossoff. No. Mr. Welch. No. Mr. Graham.
Aye.
Mr. Grassley.
Aye.
By proxy.
By proxy.
Thank you, sir.
Both those roll by proxy.
Mr. Cornyn.
Aye, in person.
Mr. Lee.
Aye.
Mr. Cruz.
Aye, by proxy.
Mr. Hawley.
Aye.
Mr. Cotton.
Aye.
Mr. Kennedy.
Aye.
Mr. Tillis.
Aye.
Mrs. Blackburn. Chair Durbin.
No.
Chair Durbin, on this vote, the ayes are 10, the nays are 11.
Mr. Chairman,
Blackburn Amendment is not agreed to. Who's seeking recognition? Senator Kennedy?
Mr. Chairman, I would call up Amendment SIL 23885, SIL 23885. This amendment would simply condemn the racist things that have been said about Justice Clarence Thomas.
Anyone seek recognition on this amendment? Senator Kennedy, is it safe to say that you condemn all racist comments and attacks on all justices?
Sure, particularly Justice Clarence Thomas. I think he has been the target of most of it.
You would not include the other African-American justices in the court?
Includes everybody in the world, but particularly Justice Clarence Thomas, because I think we all know he's been the target of most of it.
If the senator would agree to put that into the amendment, I think we could accept it.
I'm happy with my amendment.
You happy to change it, you say?
No, sir. I'm happy with my amendment. I think it's clear.
So to be clear, Senator Durbin, you're talking about simply saying that we condemn racism against any justice, but
That's all.
he will only put one justice in?
That's right.
I don't understand the reluctance to accept the fact that Justice Clarence Thomas, who happens to be a black man, has been the butt of a lot of racist statements. And I don't understand the reluctance to condemn those. And that's what my amendment does. I don't want to water it down. I don't want to bubble wrap it. I don't want to sugarcoat it. I want it to say, big as Dallas, the United States Senate condemns all these racist things that have been said about Justice Clarence Thomas. Now, if somebody wants to offer another amendment to condemn every racist thing that has ever been said in the history of ever, I will vote for it. But this one is about Clarence Thomas. And I'll support going through justice by justice, all of whom anybody who's ever served on the Supreme Court. But this one, and I think we all ought to go on record, is about Clarence Thomas.
Will Senator Kennedy yield for a question?
Yes, sir.
I'm reading your amendment, which I think is very well drafted. One of the things you cite is on July 13th, just a few days ago, 2023, Minnesota Attorney General Keith Ellison disgustingly likened Justice Thomas to a house slave from the film Django Unchained. Are there any of the other 9 justices who have been subject to such racist attack in the last few days from a sitting Democrat in the state of Minnesota who has anyone else been subject to those kind of attacks as frequently, as brazenly, and as unapologetically?
No, sir, and it would be unconscionable for this committee not to condemn that kind of rhetoric for Clarence Thomas.
Mr. Chairman, despite Senator Graham's view of the breadth of this bill and the debate, I consider this to be not relevant to the matter at hand. And further, it specifically requests the Biden administration to inject itself politically into a law enforcement decision that the Biden administration, I think quite properly, has avoided getting involved with. So I urge my colleagues to vote no.
Any further discussion on this amendment? If not,
Are you going to offer a second degree then on the?
I have some discussion.
Senator Kennedy, your amendment.
How can you not condemn a statement calling Justice Clarence Thomas a house slave? Come on, folks. That's all this amendment does. I mean, does anybody here support that kind of rhetoric? I don't. I don't think you do. And this kind of rhetoric hasn't been directed toward John Roberts. It hasn't been directed toward Neil Gorsuch. It's been directed toward Clarence Thomas. And it's un-American, it's unconscionable, and I can't believe we wouldn't condemn it. I don't care how many lawyers can dance on the head of a pin. Don't try to pretend that this is some sort of a technical mistake in this amendment. It's not complicated. You don't have to be a senior at Caltech to figure it out. It says all of this stuff about Clarence Thomas, calling him a house slave and other racist, disgusting statements we condemn. Now, you either condemn it or you don't. And that's all this amendment does.
If I may respond, I, for one, do condemn that sort of rhetoric, but the senator's amendment does more than that. It calls upon the Biden administration to enforce Section 1507 of Title 18 United States Code to protect Supreme Court justices, including Justice Thomas, in light of flagrant violations of the law designed to intimidate justices. And we've spent a lot of time in this committee trying to make sure that the White House and the political side of the executive branch is kept out of internal Department of Justice law enforcement decisions. And in the light of that, I again ask my colleagues to vote no unless there's a second-degree amendment that clears that problem.
Mr. Chairman?
I respect my colleague, Senator Whitehouse, and he's better at me counting the number of lawyers that can dance on the head of a pin. But this is a real simple amendment. If you support the racist things that have been said about Clarence Thomas, then vote against this amendment. If you think the things that have been said about Clarence Thomas are racist to the marrow and you condemn them, then vote for this amendment.
Someone else seek recognition. Senator Lee.
I support this amendment wholeheartedly, and I find it difficult to understand, number one, how someone could oppose an amendment whose sole purpose is to condemn racist slurs used repeatedly, publicly, and viciously against one Supreme Court justice. Now, yes, other things have been said about other justices. That's true. Other things have been said about other justices on both sides of the aisle. Justice Thomas is unique on the court in that, to my knowledge, he's the only current member of the court who's been attacked racially, even in supposedly polite society. Attacked by television news personalities using those same racist terms. So I find it difficult to understand why anyone would object to sending that message. Now, as to the second objection, I also find it very difficult to understand why someone would oppose this.
Don't do that.
We've already established there's nothing objectionable about wanting to weigh in and say those things shouldn't happen, they should be retracted, and they should never occur again. But now we hear an objection based on the additional fact that this amendment calls on the Biden administration to enforce 18 U.S.C. Section 1507. These same verbal attacks invariably culminate in and lead to and encourage and foment through groups like Jane's Revenge the kinds of activities outside of justices' homes that leave them in a physically vulnerable position with their personal safety and security being threatened and violated. There's nothing about this that says exactly what enforcement action has to take place at exactly what location, in what moment. There's nothing in this that doesn't take away a degree of discretion on the part of law enforcement officers. But the truth is, this is not being enforced at the homes of the justices. It isn't, and we know that it's not. We know that decision is deliberate because of the leaked internal memoranda obtained by our colleague, Senator Katie Britt from Alabama, who received them, I believe, from a whistleblower. So we know that they're being instructed not to enforce this at the homes of the justices. I find it almost impossible to understand how someone would object to this amendment, either on that basis or any other.
Senator Cruz.
Mr. Chairman, two arguments have been proffered against Senator Kennedy's amendment. The first argument is, well, gosh, maybe there have been racist things said against other justices. I will point out objectively the venom and bigotry directed at Clarence Thomas is qualitatively different from any of the other 8 justices. This resolution gives multiple instances of elected Democrats currently in office launching racial epithets with complete impunity. It cites how Representative Benny Thompson of Mississippi, a Democrat member of Congress, called Justice Thomas a, quote, Uncle Tom. It cites how just a week ago, the current sitting Minnesota Attorney General, another Democrat, Keith Ellison, disgustingly likened Justice Thomas to a house slave, and a house slave from the film Django Unchained, a particularly vicious and loathsome character from that movie. If the chairman wishes to point to instances of any elected officials using racial epithets towards any of the other 8 justices, I will happily condemn them. I'm not aware of any. Might there be some lunatic on Twitter who said something? Sure, there are idiots out on Twitter. But these are not fringe characters. This is a senior Democrat in the House of Representatives who refuses to apologize. And this is the current Attorney General in the state of Minnesota. And so everyone should understand, look, I expect a party line vote on this. I expect all the Democrats to say no. But understand, everyone watching this will interpret that quite rightly to say, you agree these kinds of racial insults at Justice Thomas are perfectly acceptable. Justice Kennedy said he assumed the Democrats denounced these statements. I have to say, I haven't heard any members of this committee denounce what Keith Ellison said. I haven't heard anyone call on Keith Ellison to retract and apologize. The Democrat Attorney General in Minnesota, I haven't heard a word about that. The second argument given was the argument given by Senator Whitehouse, and he says, well, the part that is offensive of this is it calls on the Department of Justice to enforce the law. Just stop and repeat that to yourself again. So it is now the position of Democrats that it is unacceptable to ask the Department of Justice to enforce the law. It is an existing criminal statute, Section 1507, that makes it a federal crime to protest at the home of a justice with the purpose of intimidating them. This Department of Justice refuses to enforce that law. And I will say, with the argument being made by Democrats right now, it reveals the whole game. The reason the Biden Justice Department ignores federal law and won't actually prosecute the criminals who are trying to intimidate and threaten Supreme Court justices is because the Biden administration supports that criminal threatening. And the reason now that Judiciary Committee Democrats are being told, vote no on Senator Kennedy's bill, is because Senate Democrats on the Judiciary Committee support that violent threatening of justices. This bill is not about ethics. It's about a double standard applied to justices with whom Democrats disagree. It is designed to delegitimize the court. It is applying rules that are not applied to liberal justices like Stephen Breyer and Ruth Bader Ginsburg and Sonia Sotomayor, who have committed conduct virtually identical to that of Justice Thomas and others. But the Democrats on this committee are mad at the Supreme Court because it's issued decisions faithful to the Constitution that are inconvenient for the political agenda of Democrats. Look, we're defined by the votes we make here. If every Democrat happily votes no, understand you're telling your constituents you think it's perfectly fine to call a Supreme Court justice a house slave, and you can't muster up the courage to say that's beyond the line.
Senator Cruz, would you yield to a question?
Happily.
Would you read one more time, for the record, that statement about Justice Thomas and who made it?
On July 13th, 2023, Minnesota Attorney General Keith Ellison, the currently sitting Attorney General, offensively likened Justice Thomas to a house slave from the film Django Unchained. And by the way, there's a long pattern of that. On April 27, 2014, Democrat Representative Benny Thompson of Mississippi, again another sitting Democrat member of Congress, used racially charged language to characterize Justice Thomas, including calling him an Uncle Tom. I'll point out also recently, on February 14, 2023, Georgia State Senator Emanuel Jones used similar racially charged language to characterize Justice Thomas, including by calling him an Uncle Tom figure. The choice Democrats have to make. Do you think it's all right to call a justice who dares disagree with you an Uncle Tom? I think it's bigoted. But perhaps Democrats hold themselves to a different standard.
Let me respond. We condemn racist attacks of any kind from any source, elected or unelected. We have had members, current members of the United States Senate, who've had to apologize publicly for the statements they have made involving the issue of race. We should not compromise on that integrity of that principle, regardless of whether the victim is a Democrat or a Republican, a Supreme Court justice or not. So I'm going to propose an amendment to this Kennedy amendment, which I think will encapsulate our position on this side. And if you want to go to page 3 of the amendment and follow along. It's pretty simple. On page 3, line 13, to insert after the word against, any current or former Supreme Court justice, including, and then it preserves the rest of the language you have in that line, Senator Kennedy. And to strike on page 4, paragraph 5 in its entirety. I would offer that as an amendment in an effort to bring this to a bipartisan conclusion, and it is now the pending amendment before the committee. Any comment, question?
Mr. Chairman, can I ask, so
Go ahead, Senator
as
Cornyn.
the second degree amendment, you would strike the name of Clarence Thomas?
No. Include every word on pages 1 through 3 of the amendment. I've just inserted additional language to say any current or former Supreme Court justice, including. So there's no other change.
Would the chairman consider making those amendments separately? Because the First Amendment you suggested, I'd be willing to vote in favor of. The Second Amendment, striking the paragraph calling on the Department of Justice to actually enforce current and existing federal criminal law, I could not vote for. But if you broke them up separately, I'd be happy to vote for the first one.
I have no objection to that. I think that that's reasonable request procedurally. Are there any other comments or questions? If not, then the first second degree amendment will be as follows. On page 3, line 13, to insert after the word against, quote, any current or former Supreme Court justice, including, go on to the rest of the amendment.
Will the chairman yield for a question?
Happy to yield, Senator Kennedy.
Does it mention Justice Thomas by name?
Your amendment does completely.
Yep, but does your amendment, does it take out
says-
the reference specifically to Justice Thomas?
It says including Justice Thomas,
Okay, that answers my
including
question.
those likening him. So
Thank you.
I don't delete any words from your original amendment related to Justice Thomas. Can we do this by voice vote? It sounds like the First Amendment may be agreeable. Yes or no? Senator Kennedy? Okay. All those in favor of the Durbin second degree amendment as described to the committee, say aye.
Aye.
Opposed, no. Depending on the chair, the ayes have it. So the second degree amendment, the amendment is agreed to. The amendment's agreed to. The second degree amendment strikes on page 4 all of section 5. I know that is not one that we're going to get bipartisan agreement on, so I suggest the clerk call the roll.
Mrs. Feinstein.
Aye.
Mr. Whitehouse. Aye. Ms. Klobuchar.
Aye.
Not sure what
Mr.
we're voting
Coons.
Aye by proxy.
Mr. Blumenthal. Ms. Hirono.
Okay.
Mr. Booker.
Dear God, yes.
Mr. Padilla. Mr. Asa. Mr. Welch. Mr. Graham.
No by proxy?
Mr. Grassley.
No by proxy?
Mr. Cornyn.
No?
Mr. Lee. No. Mr. Cruz. No. Mr. Hawley. No. Mr. Cotton. I'm sorry. Mr. Cotton? Thank you. Mr. Kennedy. No. Mr. Tillis. No. Mrs. Blackburn.
John?
Oh, I'm sorry, no by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The amendment is agreed to. Are there any further amendments to the Kennedy amendment? And if not, we'll call the roll on the Kennedy amendment as amended. Without objection, the clerk will call the roll.
Mrs. Feinstein.
Yes.
Mr. Whitehouse. Aye. Ms. Klobuchar. Mr. Coons.
Aye by proxy.
Mr. Blumenthal. Ms. Hirono. Mr. Booker. Mr. Booker. Mr. Padilla. Mr. Asa. Mr. Welch.
Aye by proxy.
Mr. Graham.
Aye by proxy.
Mr. Grassley.
Aye by proxy.
Mr. Cornyn.
Aye.
Mr. Lee. Mr. Cruz. Mr. Hawley. Mr. Cotton. Mr. Kennedy.
Aye.
Mr. Durbin, on this vote, the ayes are 21, the nays are 0.
The Kennedy Amendment as amended is agreed to. Are there further amendments to come before the committee? Senator Lee.
Yeah, I'd like to call up my amendment. It's SIL 23890. Purpose of this amendment is pretty simple. It creates a new federal crime for leaking confidential judicial work product to an unauthorized person. This is a crime that would be punishable by a fine of up to $10,000 and up to 10 years in prison. The amendment also allows for the criminal forfeiture of all proceeds from having engaged in this kind of criminal behavior. And it's important that we take care of this because, as we saw with the leaked draft of the Dobbs opinion, leaked draft opinions. Now, it's hard for me to speak in the plural in this respect because never in the history of the Supreme Court of the United States had this occurred, at least in this way, prior to the Dobbs case. Sure, prior to the Dobbs case, there have been a handful of circumstances in which rumors had leaked out of the court suggesting that a particular case was going to be decided this way or that. But as I've said in the past, when those rumors as to the binary outcome of the case, I mean, it's like betting on red or black at the roulette wheel. You've got a 50-50 shot of being right in most cases, because in most cases you're looking more or less at a binary result. So there are an infinite number of combinations as to what the majority might look like or what the ultimate disposition by the court, but ultimately it's normally going to come down to affirm or reverse. What happened in the Dobbs case that was so different was that a complete, authentic draft opinion of the court was leaked to the press. Now, this didn't occur in the abstract. This occurred as part of the whirlwind, part of what hit them without them even knowing. Part of the whirlwind designed to threaten, intimidate, harass, discourage those who might have had, at the moment, an inclination to support the Alito draft. Now, fortunately, the opinion was able to issue, and as far as we can tell, it didn't affect the ultimate disposition of the case. But this much is clear. It was intended to. It was also intended to draw shame, ridicule, scorn, and attention reasonably calculated to bring people to the homes of these justices to try to bring further threats, intimidation, and harassment. Ultimately, these things are ripe with opportunities for potential violence. We can't accept this. And so at the time it happened, it was not clear that this was adequately taken into account by the law. Doubtless, laws were broken in connection with this, almost certainly. It's difficult to assess it without knowing exactly who did it, as I believe it still could have been reasonably ascertained had an adequate investigation taken place. There wasn't. And I still think the court's going to have to answer for that. But we need to make it clear on the books that this is a crime, and we need to deter this kind of behavior from happening in the future.
Mr. Chairman.
Before I recognize Senator Blumenthal, let me just comment on the amendment itself. I'm going to oppose this amendment. I'm sure that among Senator Lee's close friends and colleagues, there's a sincere belief that whoever disclosed this must have been some damn liberal who was trying to upset the Dobbs decision. I can tell you in my corner of the political world, the opposite is argued. It must have been Alito trying to solidify the position of the court justices who had committed to his decision, and he wanted to get it done as quickly as possible. I don't know who is right on that assertion, the right or the left, but I do know this. When the investigation was ordered by the Supreme Court Chief Justice of the court itself to find out the source of it, I didn't hear anyone from the right arguing we need to weaponize the Department of Justice. Let's bring them in. Now we have a different point of view, and I don't think it is consistent, number one, nor relevant to the issue that is before us. This is about the code of ethics for the Supreme Court. It is not about the integrity of the court and its own dealings within the court. but rather their reputation with the rest of the world, including American voters. Senator Blumenthal.
Thanks, Mr. Chairman. First, a question to Senator Lee. Would the Department of Justice be responsible for enforcing this section of the criminal code and potentially or likely investigate the United States Supreme Court?
The criminal code is itself enforced by the United States Department of Justice. Federal criminal laws
the
are
Department of
pursued by
Justice
the
would
DOJ.
investigate this crime.
That doesn't mean that in every instance outside law enforcement would be free to go in and raid the court, but in circumstances where they believe they know who did it or concerned,
Well, as Senator Lee well knows, when you begin a criminal investigation, you don't always know who did it. In fact, the likelihood is you don't know who did it.
You don't know, but
suspicion.
sometimes you do. And where you do, we need to have a criminal offense on the books. And contrary to what the chairman said a moment ago, this is not groundbreaking. This is not new. This is based on and closely mirrors something we have from an analogous parallel provision of the code in 18 U.S.C. Section 798 that relates to the release of classified information. This is slightly different than classified information because it's not of the national security secrets sort of variety.
Let me just second what the chairman said. I think that, first of all, the amendment is not germane. I was as outraged by this leak as I'm sure Senator Lee was as a former law clerk on the United States Supreme Court. Both of us, I think, respected the rules of confidentiality that apply, and I think both of us would at least question, the circumstances under which the Department of Justice would begin literally interrogating members of the United States Supreme Court, which is what this amendment would almost certainly invite. And let me just say generally, I think both of us, Senator Lee, have tremendous respect for the United States Supreme Court. We've both been law clerks. I've argued a number of cases before the court. And frankly, I think that what's happening in this debate is, in fact, further degrading and detracting from the credibility and trust of the public in the United States Supreme Court. Senator Lee just referred to, and I'm quoting, justices on both sides of the aisle, end quote. That is the way the public is beginning to see the United States Supreme Court. Just like any other political body, politicians wearing robes, and that ultimately is destructive to the court. The fact is, the Chief Justice of the United States Supreme Court could diffuse this debate and address this problem by coming forth with a code of ethics on behalf of the court. And his failure to do so is, in fact, the reason that we're here today. We're not talking here about justices on one side of the aisle or the other. We're not talking about appointees of Republicans or Democrats. Both Republican and Democratic appointees have been responsible for ethical breaches that bring us here today. And I continue to urge the Chief Justice of the United States to demonstrate the leadership that would help save the court and this very significant democratic institution. Thank you.
Senator Lee.
Thank you, Mr. Chairman. I appreciate Senator Blumenthal bringing to my attention a slip of the tongue. Normally, when I make that reference, what I'm referring to is justices who have been appointed by presidents on both sides of the aisle, in both parties. Apparently, from your quote, I must have botched that in one instance. That is a force of habit by virtue of the halls we inhabit rather than those. So if I misstated that there, that was a mistake by me, and thanks for pointing that out. Your suggestion as to germaneness isn't relevant here. There isn't a germaneness standard within the committee. It certainly is relevant to the topic that we're talking about. On your separation of powers point, I've got a few thoughts there. First of all, you're correct in pointing out that we don't want outside law enforcement feeling free to just barge into the Supreme Court and investigate within the court itself. Nonetheless, everyone understands, everyone understood at the time the court undertook its own investigation, an investigation that I think didn't go far enough, but had they obtained information that was capable of identifying the person who undertook these activities, I have no doubt, and I don't think anyone has any doubt, that they would have referred those things to the Department of Justice and allowed the Department of Justice to take it from there, continuing the investigation and making a decision ultimately as to whether to pursue charges through a grand jury. That didn't happen. But the separation of powers concern you raise is legitimate, but that it doesn't mean that this statute isn't necessary and that it wouldn't be helpful, that it wouldn't be desirable, and that we don't need it. It is indeed significant to raise the separation of powers concerns here in light of the very significant separation of powers concerns raised by the underlying legislation. Remember, we are a coordinate branch of government relative to the Supreme Court. And we have to tread very lightly here, lest we undo the judicial independence that has become the hallmark of our system. So for that reason, yeah, I don't agree with the criticisms on this bill. I also firmly reject any suggestion. You say you don't know who did it, Mr. Chairman. You don't know whether those rumors about Justice Alito doing it are true. Well, I do. Not a chance in hell he did that. Not a chance in hell. I've known the guy for more than 25 years. It is not in his character, nature. There's not a single thing about him, about his incentives, about his past conduct, about simple logic that would suggest that it is him. Regardless, whoever did leak the opinion, well, we don't know who that person is. I'm absolutely certain it's not him. Whether you agree with me or not is beside the point. We still need a statute that takes care of this problem. Thank you.
Senator Feinstein.
I'm going to vote no, and I just want to give the reason. I'm advised and believe that the amendment presents significant First Amendment concerns in limiting speech, especially of journalists who publish leaks from the Supreme Court, which may be one of the significant public interests, could face significant imprisonment under this amendment. That's the analysis of my legal staff.
Thank you, Senator Feinstein. The question is on the adoption of the Lee Amendment. The clerk will call the roll.
Mrs. Feinstein.
No.
Mr. Whitehouse.
No by proxy.
Ms. Klobuchar. No. Mr. Coons.
No by proxy.
Mr. Blumenthal.
No.
Ms. Hirono.
No.
Mr. Booker.
No by proxy.
Mr. Padilla. Mr. Ossoff. Mr. Welch.
No by proxy.
Mr. Graham.
I vote proxy.
Mr. Grassley.
The amendment is not agreed to. The next on my list on the Republican side is Senator Hawley.
Thank you, Mr. Chairman. I'd like to call up Hawley Amendment number 4, which is LEW 23329. You know, I welcome the discussion about ethics reform. What I notice is that this body has a habit of prescribing rules and standards for other people and then not looking to its own problems, whether it's Obamacare or initially it was you all follow these rules, something different for us, or whether it's what's happening right now, where, for instance, in the last Congress, 1 in 7 members of the House and the Senate, 1 in 7, that's a big number, violated current laws on the books, the Stock Act, by failing to report their stock trades properly. 97 members of Congress, House and Senate, or their spouses or dependents, traded on companies that were directly affected by the committees they sit on. More than 1 in 5 of senior federal officials in the executive branch currently hold stock in companies that they were supposed to be regulating. And there has been a series of reports in the press recently about the Department of Energy in particular, where a huge number, I think it's 2/3 or more, members can look to make sure that I'm getting the statistics right, a huge number of senior officials in the Department of Energy currently own stock and trade actively in stock on companies that DOE has direct oversight of. That includes the Secretary of Energy, who represented to Congress under oath that she had no individual stock. It turns out she did have stock. She was trading that stock. It included companies that DOE has direct oversight of. Now, Senator Welch mentioned earlier that Americans are surprised at some of the ethics requirements that are or are not in place at the U.S. Supreme Court. This is one when I talk to people at home about members of this body owning and trading an individual stock, or members of the executive branch owning and trading in stock of companies that they're supposed to be overseeing, people are shocked that it's even legal. So my proposal is a simple one. If we're going to talk about ethics reform, let's make sure we're looking at ourselves as well. So I'm proposing here to amend this provision, this bill before us, to include a ban on stock ownership and trading for members of Congress and senior executive branch officials. It's a bipartisan bill. Senator Gillibrand and I have introduced it as a standalone bill. I've converted it here to an amendment, and it would impose across-the-board ethics reform and make this uniform in the sense that we would be addressing ethical lapses that are real and pressing in our own body, in our own House, as well as the executive branch. And I ask for a roll call vote.
Thank you, Senator Hawley. This amendment seeks to prevent members of Congress and the executive branch officials from owning certain securities and investments while they serve in those positions. We should have a conversation around legislation to ensure members of Congress and executive branch officials aren't engaged in insider trading. This is an important subject that the Senate can and should address, and I'll join in that debate. Unlike Congress and the executive branch, the Supreme Court is not bound by any ethical code of conduct. That is the purpose of this hearing and the pending legislation. That's why we're focusing on it today. Turning our attention elsewhere is a distraction. I'll therefore oppose the amendment. Anyone else seek recognition? If not, the clerk will call the roll.
Mrs. Feinstein.
Aye.
No.
Oh, excuse me, no.
Mr. Whitehouse.
No by proxy.
Ms. Klobuchar.
No by proxy.
Mr. Coons.
No by proxy.
Mr. Blumenthal.
No by proxy.
Ms. Hirono. Mr. Booker.
No by proxy.
Mr. Padilla. No. Mr. Ossoff. No. Mr. Welch.
No by proxy.
Mr. Graham.
I'm by proxy.
Mr. Grassley.
I'm by proxy.
Mr. Cornyn.
No by proxy.
Mr. Lee.
I by proxy.
Mr. Cruz.
Aye.
Mr. Hawley.
Aye.
Mr. Cotton. Mr. Kennedy. Aye. Mr. Tillis. Mr. Tillis.
No by proxy.
Mrs. Blackburn.
I by proxy.
Chair Durbin.
No.
Mr. Chairman,
Who seeks recognition? Senator Ossoff?
I'd like to be recorded as an aye on this vote, please.
Senator Klobuchar?
I was not briefed on this by our staff, so I'm going to vote no for now, but I'm going to look at it later on. Thank you. I have just very big concerns about ethics in this place right now.
Chair Durbin, on this vote, the ayes are 7, the nays are 14.
The Hawley amendment is not agreed to. The question before us is the Cotton amendment.
Mr. Chair,
Would you please designate which amendment?
I call it my amendment number COT 237A13. Mr. Chair, any member of the press, any person, in fact, can read and report on the opinions of the Supreme Court. Those opinions are published online within moments of being issued, and the briefings and arguments are public as well. However, the Supreme Court also confers special privileges on journalists, including special access to and assigned seats in the courtroom, a desk in the court building itself, access to the court after hours, and information not provided to the public. So I'd suggest if we're really concerned about transparency in our court system, the public also needs to know about the conflicts of interest of those who have special access at the court. My amendment would require that, to be recognized by the Supreme Court as press, reporters and media outlets must meet two conditions. First, they have to make publicly available a list of their funders so we know what special interest or political causes are embedding their own personnel literally within the Supreme Court building itself. And second, they must certify under oath that they will not disclose any information about internal draft opinions or court deliberations unless the Supreme Court authorizes it. If you're going to help leak information that damages the court and the public's confidence in our legal system, you at least should do so without special after-hours access to the court building itself. I urge my colleagues to vote yes.
Thank you, Senator Cotton. We're trying to locate your amendment. I apologize. And the number was COT 237A13, is that correct?
Correct.
Well, I'm going to oppose this amendment, and I'd like to explain why. This amendment focuses on reporters who are simply doing their jobs instead of the court for its failure to maintain confidentiality in its opinions. Too often, we allow the Supreme Court to get away with misconduct that would not be allowed in any other part of our government. The Supreme Court justices play by their own set of rules while the other branches of government are bound by law. This amendment would continue that pattern and reduce public disclosure. This amendment would not achieve the purpose of this bill and would unduly restrict freedom of the press. I urge my colleagues to oppose it. Anyone else seeking recognition? Clerk will call the roll on Cotton Amendment COT 237A13.
Mrs. Feinstein?
No.
Mr. Whitehouse?
No.
Ms. Klobuchar?
No.
Mr. Coons?
No by proxy.
Mr. Blumenthal?
No.
Ms. Sarono? No. Mr. Booker?
No by proxy.
Mr. Padilla?
No by proxy.
Mr. Ossoff?
No by proxy.
Mr. Welch?
No by proxy.
Mr. Graham? Mr. Grassley? Mr. Cornish? Mr. Lee? Mr. Cruz? Mr. Hawley? Mr. Cotton? Mr. Kennedy? Mr. Tillis? Mrs. Blackburn? Chair Durbin?
No.
Chair Durbin, on this vote, the ayes are 10, the nays are 11.
The amendment is not agreed to. The next amendment is offered by Senator Cruz, and I'm going to excuse myself to vote on the floor in return. Senator Whitehouse has voted, and I'll turn the gavel over to him. Senator Cruz, you're recognized.
Thank you, Mr. Chairman. I'd like to call up my amendment SIL 23800. This amendment is very simple. It consists of one sentence. The Supreme Court of the United States shall be composed of 9 justices. There has been considerable debate about the efforts of the radical left and the Democrat Party to pack the United States Supreme Court, to add 4 left-wing justices immediately to the court to grow the number from 9 to 13 because Democrats are unhappy with the decisions that are being issued by the Supreme Court. When FDR tried to pack the court, it was widely recognized to be a grotesque abuse of power, undermining the rule of law. That was true then. It's true now. Some Democrats in this body claim, at least when they return home and talk to their constituents, that they do not support packing the Supreme Court. This amendment is an opportunity to go on record and be clear whether or not you support packing the court. I would urge adoption of the amendment.
Thank you, Senator. The Constitution, of course, does not stipulate the number of Supreme Court justices. That is a decision of Congress. We have a long history of altering the makeup of the court. The number of justices has changed 6 times before we landed on the number 9 in 1869. There's only one living senator who has changed the size of the Supreme Court. That is Senator Mitch McConnell of Kentucky, who shrank the court to 8 seats for nearly a year and for purely political reasons, so he could refuse Merrick Garland's nomination by President Obama. Republicans engaged in court packing plain and simple when they refused to consider then-Judge Garland's nomination in 2016 and then hurried through Justice Barrett's nomination in 2020. My Republican colleagues routinely try to forget and ignore this history. Republicans' insistence now that the Supreme Court must remain at 9 seats and their hysteria over Democrats even discussing a change does not square with that count that I just gave you. Ultimately, however, this amendment is unrelated to the bill before us and the very real need to ensure the courts put in place an enforceable code of conduct. I will therefore oppose the amendment. Anyone else seek recognition?
Mr. Chairman,
Senator Cruz.
if I could respond briefly, it is true that Congress has the authority to change the number of justices on the court. The last time Congress exercised that authority was in 1869, just after the Civil War. So it has been a long time that we have had 9 justices. That is why when FDR tried to pack the court, even Democrats said this was an abuse of power. It's an interesting commentary that in the 1930s, Democrats in Congress recognized that packing the court would do real damage to the rule of law, to the Constitution. Today, Democrats no longer believe that. The chairman tries to engage in wordplay by saying the Senate exercising advice and consent is somehow packing the court. It is true that when President Obama nominated Merrick Garland, the majority of the Supreme Court made the decision not to confirm him. That is not packing this court. That is exercising the constitutional authority of the Senate to advise and consent, and in that case, to allow the voters to make a decision. Justice Scalia passed away in February of a presidential election year, and the history had been true for 8 decades that when a vacancy occurred in a presidential election year and the Senate was in the opposing party's hands, the Senate did not fill that vacancy, but rather allowed the voters to decide. That's what the Senate did. I understand Senate Democrats are unhappy about that. I also understand Senate Democrats wish Hillary Clinton had won instead of Donald Trump. That's not, in fact, what happened. Packing the Supreme Court means one very specific thing: adding additional seats to change the balance of power because you are unhappy about how the Supreme Court is ruling. It is directly interfering in the administration of justice, and it is profoundly dangerous. And I got to say, it's going to be sad, but it's going to be revealing. The next time some Democrat goes on the trail and says, no, 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 we're not going to pack the court, just remember what you're about to see, which is going to be every Democrat voting against the Supreme Court consisting of 9 justices, because today's Democrats, it is partisanship above all else, including the rule of law. This bill reflects that, and a willingness of Democrats to try to undermine the legitimacy of the Supreme Court. But the willingness to pack the court shows just how radicalized today's Democrats have become.
Chairman.
I'll recognize you in just one second, Senator Whitehouse. Perhaps the senator from Texas recalls a meeting of the Senate Judiciary Subcommittee on Oversight, which you chaired, and in which you accused the Supreme Court of activism and called for the need to, quote, rein in judicial tyranny over the Obergefell decision. Last month, shortly after the High Court handed down a 5-4 decision that made marriage equality the law of the land, you vowed to propose a constitutional amendment that would effectively upend Article 3 of the U.S. Constitution and subject justices to periodic retention elections. The sacred number 9 was not honored during the month of 2016 because it was last year of Obama's presidency. Unpacking a court by Senator McConnell with the express purpose of a political result. So I still oppose this amendment. Senator Whitehouse.
Thank you very much, Mr. Chairman. Like so many of our Republican friends' amendments today, this is not related to the bill at hand. And I would note that we are here discussing this because of the ethics mess that has taken place at the Supreme Court. We certainly know that a lot of improper things have happened and have not been disclosed. I think the multiple billionaire-funded private jet flights to various places are pretty self-explanatory as inappropriate. The excuses that have been made to try to justify them don't pass the test of, frankly, what other federal judges would tolerate in a courtroom. And until we know what the true depth is of the problem at the court, it's impossible to know what the appropriate response is. So I have not spoken out in favor of adding a number to the court, but I don't think we should foreclose that in an amendment here because we don't know yet what the whole story here is. We have a lot of investigative work to do to get to the bottom of it. We saw another important article come out just this morning about the nexus between Leonard Leo and his front groups and his billionaires who fund him and one of the justices on the Supreme Court. It just keeps getting worse. So I would urge a no vote on this amendment, and I believe we have a quorum to vote.
On the Cruz Amendment 23800, the clerk will call the roll.
Mrs. Feinstein.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar. Mr. Coons.
No by proxy.
Mr. Blumenthal.
No by proxy.
Ms. Hirono. Mr. Booker. No. Mr. Padilla. No. Mr. Asa.
No by proxy.
Mr. Welch. Mr. Graham.
Aye.
Mr. Grassley.
Aye by proxy.
Mr. Cornyn.
Aye by proxy.
Mr. Lee.
Aye by proxy.
Mr. Cruz. Mr. Hawley. Mr. Cotton.
Aye by proxy.
Mr. Kennedy.
Well, somebody should take it.
Aye by proxy.
Mr. Tillis.
Aye by proxy.
Mrs. Blackburn.
Aye by proxy.
Chair Durbin.
Nope.
Chair Durbin, on this vote, the ayes are 10, the nays are 11.
The amendment is not agreed to. If there are no more amendments, we're going to vote on final passage.
We have to what?
On favorably reporting S35.
This is on the bill?
Mr. Chairman,
Senator Whitehouse.
I would like to make a few points as we wrap this up. The first is I would react to the comments of some of my colleagues that Democrats want to pack the court. My sense is the court has already been packed. It has been packed as the result of a very long and expensive effort run by a handful of secretive right-wing billionaires through a bunch of front groups. The tally of the cost of the operation has risen from the original $250 million estimate of the Washington Post to now $580 million spent on trying to make sure that those billionaires succeeded in what has been characterized in this room as the long effort to make this a conservative court. The question of whether or not it is appropriate for lower court judges to stand in some degree of judgment over the administrative question of whether or not there's compliance with rules is actually the current state of the judiciary. That is the way it works right now. So objecting to that is objecting to present reality. Let me start by pointing out that there are two sides to a judge's job. One is the judicial side, adjudicating matters, and the other is administrative side, which includes the ethics part of a judge's job. You have a clue which role the judge is playing if they're wearing a robe. If they're not, it's very likely the administrative side of their work. In the administrative side of their work, where the ethics questions are handled, those determinations go to the Judicial Conference. That's the same body I mentioned earlier that was established by Congress and that implements the financial disclosure laws passed by Congress and the recusal laws passed by Congress. It is made up essentially entirely of lower court judges. One justice sits on it as chair, the Chief Justice. And questions about financial disclosure of the justices are sent there now. We know that because we've seen it happen. In the first round of Harlan Crow to Clarence Thomas yacht and jet free travel disclosures, back in 2011, that was sent to the Judicial Conference and to its Financial Disclosure Committee. Its Financial Disclosure Committee is composed entirely of lower court judges, circuit chief judges and district chief judges. That is who resolved the matter of that first round of gifts from Harlan Crow to Clarence Thomas. And the second round, right now, that the Judicial Conference is reviewing, was again sent to the Financial Disclosure Committee, again made up entirely of lower court judges. So the objection that lower court judges would make a determination about whether justices have complied, for instance, with financial disclosure rules, that's the present state. That's the present state. And the other question that went before them recently was this question of Justice Scalia's maneuver, you want to call it that, of reading a personal invitation from a resort owner with whom he had no personal relationship as a matter of personal hospitality. When that question went back for determination, it went back to the Judicial Conference. And it was the Judicial Conference made up of lower court judges that said, no, that doesn't fly, that is not legal, that is not what the personal hospitality disclosure rule permits. So thank you for letting me have a chance to make that record. I don't know if we have the... I don't know if I'm holding up a vote at this point. No, not yet. Okay, we're still waiting for people to come back from the voting. So, you know, there are a lot of canards that are flying around in all of this. The canard that lower court judges can't make decisions about the administrative side, the ethics piece of Supreme Court justices' behavior is just simply belied by the fact that it has happened exactly that way over and over and over again, and without objection. Without objection. When Justice Thomas's first round of secret yacht and jet gifts from Harlan Crow was referred to the Financial Disclosure Committee, he did not say, wait a minute, you can't send that to that body. They're all lower court judges. He went along with it. And no Supreme Court justice has ever complained about lower court judges through the Judicial Conference exercising their judgment about administrative, financial, and ethics matters. So that just ain't so. And the argument that we are up against an attack on the independent judiciary and that this violates separation of powers, again, is belied by the acts of the justices themselves. The Judicial Conference has existed for decades. The court knows it exists because the Supreme Court Chief Justice chairs it. They have never objected to that being an intrusion into separation of powers because it was established by Congress. And the financial disclosure rules that Congress established. Again, when the matter about the first round of Harlan Crow to Justice Thomas secret yacht and jet travel gifts was sent to the Judicial Conference, nobody said you can't send it there because it violates separation of powers. They didn't say you can't do it because it's lower court judges, and they didn't say you can't do it because it's separation of powers. And that's because both of those arguments are completely false. There are ways to solve this problem that work squarely within the constitutional principle of separation of powers, a principle that I revere. As one of my Republican colleagues said today, there's also the question of checks and balances, and that we have to allow power to check power. Allowing Congress the power to check abuses in the judicial branch is a long established and proven fact that the Supreme Court has for decades gone along with without complaint, even when, and perhaps particularly when, it involved justices themselves. And indeed, after the Judicial Conference said, nope, you cannot fake personal hospitality if it's a corporate venue. You cannot fake personal hospitality just because it's a personal invitation. You cannot fake personal hospitality if there's not a real and long-standing personal relationship. When they said that, they were exercising powers given to them by Congress. And there was no objection to that from the Supreme Court. Indeed, Thomas put out a rare statement saying he would abide by that. He did not say that's unconstitutional. He did not say lower judges shouldn't do that. He did not say there's a separation of powers problem here. He said, yep, I will follow that new rule.
On favorably reporting S-359, the Supreme Court Ethics, Recusal, and Transparency Act, the clerk will call the roll.
Mrs. Feinstein.
Aye.
Mr. Whitehouse.
Aye.
Mrs. Klobuchar. Aye. Mr. Coons. Aye. Mr. Blumenthal. Aye. Ms. Hirono. Aye. Mr. Booker. Aye. Mr. Padilla. Aye. Mr. Ossoff. Aye. Mr. Welch. Aye. Mr. Graham.
No.
Mr. Grassley.
No by proxy.
Mr. Cornyn.
No by proxy.
Mr. Lee.
No by proxy.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy. No. Mr. Tillis.
No by proxy.
Ms. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The bill will be favorably reported to the floor. If no further business to come before the committee, we stand adjourned.